number 1. So timing no class.
So this is very unfortunate, I must tell. And this matter was listed in some other court. How have you mentioned?
This matter listed last week also in this court.
Because you misled the court.
No, it was
You misled the court without informing that this matter is being listed some other court. You say that is connected matter. I didn't see that. I took up the matter. It was listed in some other court.
No, it is regarding the tedious matter.
I know that tedious matter. I saw that. My staff then got that proceeding sheet of the other court. Please don't do that. I believe the lawyers. It is very unfair. I took up the matter thinking that it is a connected matter. Whereas this matter is listed today before some other court. I pick up that matter thinking that it is connected because you have not said that this matter is listed some other court. What is this going on?
Item 70.
Yes.
60. Item 70. Kindly adjourn after petition.
Everybody is asking for a adjournment today. I think I am
Coming to make a mention, my lord.
Item 77.
No, old matters I will not. I'll tell you. These are the matters from 2008 onwards. Are pending here, still is operating since last more than a decade.
Item 16 has come up for the first time.
I know all the matters are coming up first time because I told the registry to list all the matters.
Item 77.
I will just check it up. What is the matter? Old matter don't judge. None of the old matter will be.
Item.
I will just check it up. After a lot of struggle, I got them.
In item 77.
Necessary, I'll do it. Not that I'll pass in order, but it should roll over, you know. I'll just check it up and make it.
Item 46, my lord.
See, many cases where the matter is already infectious, but the stay is operating. So let us understand what it is. Let me understand.
My lord, item 46. My lord, conducting counsel was supposed to appear today in suffering from dengue. My lord, kindly make the taken this matter in item 46.
Wait for it. 1 minute. Seniors are waiting that first leave reference to the seniors. My state, give it, we'll see. All the matters will be. You are the informant. I am for the
Akship, item 64, paying for it.
I told, see, just see.
No problem.
Item 74.
Item, your lordship's item.
1 minute, Mr. Knight.
Your lordship.
I'll come just. I'll mention
Item 74. Whatever required to file objection by mine department the criminal matter. So Rasimi keep out after vacation. 74. You know the object part.
Okay. 74. Legend. Okay. You ready for compound? See compound, who stop? Who the compound?
In that case, entry model is there.
Entry model.
Is there? It's under I. This is mission to
You can hit. And you say that you want to compound it.
The petitioner is ready and willing to pay the amount. That is the whole.
Okay, you take it. Just small matter.
So basically, item number 77, the petitioner advocate is filing the reply to the objection of
Yeah, an old matter.
In item 77, Lord.
Yes.
I am filing the objection today and will solve the conflict.
Immediately after the case.
Objection and
the party seeks to file the reply during the course of the.
I am for the petitioner. I am for the petitioner. He is asking for time. 77. The interim order dated 7/3/24 extended.
Entry model to continue. Yeah.
Item 17, your lordship. Item 17, 6% adjournment. 17.
Bail matter.
Bail matter.
Why are you seeking adjournment?
I will maybe some.
Okay. Yes.
Item number 12, madam. Permitted to withdraw. I have filed a memo for withdrawal.
Executed.
Huh?
Executed or what?
That initial lady lordship, may I kindly remember. They have amicably settled their matter, so
Withdraw.
my lord, item number 2, my lord.
Yeah.
I am permitted to adjourn this matter after vacation.
Why? What is this?
Item number 2.
Entry order is there.
No.
Or then.
Item 11, madam. Honorary lawyer is the accommodation.
11.
Kindly come next to it.
Bail matter. Not next week. We will go to.
Same accommodation next week.
Lordship, item 64,
Yes,
going
yes.
for an adjournment. Your Lordship, as Mr. S.S. Das is not well. It's an old matter, Your Lordship, 2011, but there is no stay granted.
There is no stay.
No, Your Lordship.
Matter still survives or not?
It was actually disposed of earlier, Your Lordship. It has been restored in the month of February this year.
This is for cognizance.
No, Your Lordship, not for cognizance.
What? Question.
Yes, Your Lordship, for
So
question.
now the trial might have been concluded by now.
No, Your Lordship, in the lower court, no proceedings have not proceeded. We had given, at the time of the restoration, we had filed an affidavit regarding the status of the proceedings in the lower court as well. So,
You two certificates, huh?
yes, Your Lordship, thereafter, this is the first time after restoration, it has been listed for the first time today. Mr. S.S. is engaged to appear, but he is not well today.
This week, leave it next week immediately. On third one.
Obliged, Your Lordship.
Yes, Mr. Kedia, somebody mentioned the matter which you argued.
Your Lordship, today the matter was not listed.
Huh?
Matter was not listed in that court.
But how will it be listed? The matter has come to this court.
Lordship.
I have sent it, but this confusion has been created by this thing. It should have pointed out, but I told him that.
Item 6, let's kindly second over after vacation. Item 6. Criminal revision.
Item 46, I prayed for 2 weeks after.
Your Lordship's item 46. Item
Yeah.
46 is a CBI matter. Please wait. Your Lordship's item 46 is a CBI matter.
Somebody asked
Wait.
for
No. Please take it over.
Yes.
Your Lordships had made it clear that no further adjournment will be given because of the fact that this is that cancellation of bail matter, Your Lordships, where he was threatening the IO and was telling that I have paid 5 crore rupees and got bailed. Same matter, Your Lordships.
Conducting counsel, Mr. VP Singh is suffering from dengue. He is
Mr.
unable
Lalit
to.
Mishra was Your Lordships had made it very, very clear that no further adjournments will be given.
Power is there, but not reflected in the first list, madam.
See, there is a peremptory order.
My lord, he is unfortunately suffering from.
You, Your Lordships.
All the week commencing from, let us list on that. If dengue is suffering it, personal difficulty.
Your Lordship, Mr. Lalit Mishra is there. He was arguing last time.
My lord is.
Whatever, some lawyer is suffering from dengue, we can't be harsh on that. Let it be, huh? Let it be. I'll list it immediately on third or so.
Your Lordship, fix a date and time and no further adjournment should be given, Your Lordships.
Fourth or fifth elect.
Item number 70. Kindly adjourn to after vacation.
What?
Item number 70.
Matters?
No, my lord.
Okay, adjourn. Yes. Certainly.
Item number 50,
Mr. Yes, Mr.
item number 51 may be permitted to withdraw.
51 or 52?
51.
Permitted to withdraw, yes.
Item 1, my lord. Business matter, Mr. Mahana, my lord. Mahana admission. I will seal the password. Password.
You want an adjournment?
No, I want to do because suffering.
I never see, he is having a.
Another court. My lord is taking that.
You lease it in the, fifth or sixth.
Maybe
That's what he says.
other matter if they collide.
It's all right. All right.
Pass
over, why you are wasting time? Pass over, yes.
Kindly accommodate me.
Yes, I'll be there, yes. Item?
Item 3.
3, yeah.
Item 3.
Beg pardon, my lord. I am mentioning that matter, one matter, because
2 o'clock mentioning.
My lord, I am waiting.
Mentioning, please, hold on. Mention at 2 o'clock now. Yes.
Regular appeal, 3 years conviction. Item 3. I am appealing this time.
I am admitting it.
What I'm saying is this, my lords. The lordship is admitting it, but the facts, I just placed 2 things and there's a question of law. So I thought I might just tell what it was, my lord. Here what has happened is, my lord, on admission. No, I want an admission and question for more, my lord, in fact. So that is why I will have to, my standard is higher.
Stay of conviction.
I have to seek a stay of conviction, my lord. The facts are egregious. So what has happened is, there is a cooperative society. That cooperative society has provisions under Rule 12 of the OCS rules as to how they can be disposed. Under those rules, all the steps, the finding is that all steps have been followed. I am an accountant working in that cooperative society. There were 3 accused here: the president of the society, the buyer, and me, the accountant. I was officiating as a secretary. Now, under the process, the rules, what has to be done is that the president has to constitute a sale committee. That sale committee has to find a government approved valuer. That valuer has to do valuation of the land. Then it has to come back to the committee. Then the committee will put it up before the board of BOM. And then the BOM has to give a finding as to whether the sale should proceed or not. And thereafter, a unanimous decision is taken for or against. The allegation against me
needs to be ratified by the registrar.
And then it has to be communicated to the
Society,
your lordship is aware. Yes, your lordship is aware. So here the allegation against me is that I executed the sale deed. On the instruction of the board of management, the only allegation against me is I executed the sale deed. And the person who has seen it through, in fact, the president has gone beyond the rules. He is directly negotiated with.
Show me the resolution of the society authorizing you to sign the.
It is recorded in the improved order.
Show me I need to see that document.
Whether that document is not.
Whether that document is exhibited. Whether if it is exhibited, whether it is ratified by the registrar of cooperative society or not, these aspects need to be
gone into, yes. So, and that is one, my lords. The second thing is a peculiarity in law, my lords. Your lordship is aware, the PC Act has been amended in 2018. Now, what has happened in
13(1)(e) and all.
Yes. So, what has happened is that 13(1) has been substituted by the amending act. This argument has been raised before 2 high courts who are in session of the matter.
When the offence had taken place, that time what was?
Yes. So what exactly? That is precisely in criminal law. That is the position that on the date of occurrence of the offence.
Yes.
But here the statutory framework is this, that the provision which stands omitted without a savings clause in the amending act, which will mean that the provision
is pending in Delhi High Court.
Yes, correct. One is pending in the Delhi High Court. Yes. So it's still pending, my lords. So that is the precise question we raised here.
What happened to the provisions which were omitted?
Yes, and not
that being a saving clause.
Correct. Under the Income Tax Act, the understanding, my lord, is they stand obliterated as if they never existed.
It was never existed.
That is correct. That is the view. That is the view. That has to be decided by a court someday. So I thought,
what happened to those matters?
They still pending.
Still continue.
They're still pending, my lord.
Pending.
Still pending.
And you address this issue. I don't think on that point there is any deliberation by this court.
No, not by the registrar.
If you can assist, then
I will be deeply
we can
yes.
Have an order.
Yes.
Judgment on that.
Yes, madam. No, we do the 3 applications. Yes.
On facts, I have to call for the record.
Right.
Let the record come. I'll fix a date insofar as this aspect is concerned.
Right.
On the point of law, omission of a particular provision from a statute without there being a saving clause. Whether on that basis can you convict or not? That is the
right.
To address on that.
Yes.
You can satisfy me, then I
may pray before your lordship to have a glance to flag C.
Flag C?
Flag C, the petition itself, 2279.
Yes.
Yes.
Yes, sir.
Application for suspension of sentence, unless sentence is suspended, Bail cannot be granted and a fine cannot be stayed. So that there is no stay of conviction prayed. So hence it should be withdrawn. Better petition for stay of conviction should be
Application. You move.
suspension of sentence and stay of conviction. Different things.
Executive part of the judgment has to be stayed.
Right.
And the sentence part is executable.
Right.
So therefore it is stayed.
Right.
Insofar as conviction part is concerned, it is not executable.
Right.
When it is executable, when you are going to be terminated from service.
Right.
That time it is put to execution.
Right.
So therefore you can come for stay.
Suspension of sentence.
Suspension of that conviction.
Conviction.
But you have asked for suspension of sentence.
Prayer also.
Suspending the
Prayer also.
yes.
Same. So it should be withdrawn and better petition may be file an application.
Press application with the addressing the question.
I will call the objection.
The appeal is admitted. The petitioner is enlarged on bail. The realization of the fine is paid. Mr. Mishra and counsel for the petition appellant submits that he would be moving an application for seeking stay of execution of stay of the conviction on the basis of legal issues.
Right.
Legal issues. He may file such application. If such application is moved, the same shall be advance copy of the same shall be out on the counsel for the witness. Release the matter, release the application for hearing. Give a date immediately after.
I will file my objection. After serving a copy, I will file my objection. Thereafter, it may be listed as my prayer.
Das may file objection to the application. It should be exhaustive application, not formal application. With all legal provisions and all, so that we can deal with.
Reply to
Release the matter immediately after vacation, anytime. You tell me the date when you can come and tell.
Any date.
Yes. Immediately after vacation.
Not a Monday or a Thursday.
Only the application, not the application.
Not a Monday, Thursday.
Yes.
No, Monday, Friday.
Along with the relevant
Provisions.
relevant documents also. LCR,
Yes,
LCR also.
Documents may, copies may be supplied to me. I will LCR.
This issue you address so that
Because that
I don't know
not been decided.
in Delhi there are many matters now. So that matters are not being decided.
So there's no finality on that aspect.
So we can decide.
Right.
Yes.
Right. Deep problem.
And fourth,
Yes, sir. Case of issue can conviction of 2 years and 10,000 fine.
Admit same order. Bail granted and the realization of fine is taken.
Both the matters, my appearance and
Yes, same. That part is there, fixed. That part is fixed. Yes.
Five, may I please your lordship? I am appearing through virtual court.
Yes.
Your lordship, I have challenged the impugned order dated 15/2/2024 passed by this learned special judge vigilance Bhavani Patna in GRB case number 17 of 2021, which is marked as exhibit annexed to your lordship, page number 224 to 228. This is a dismissal order of a discharge petition of your lordship.
Director charge has been framed in same page, 226.
Now charge has been framed.
Page 226, last 3 lines. And that part, yes, very fairly stated, incorporated all the 164 statement. I'm placing that statement at page 124. Because that CB4 madam, this is a case, a demand of 80,000 for the passing of bills picture as applied to the government. CB4 madam, the accused more. पैसा आनिछो कि नहीं बोली पचाइला मु आनिछि बोली कहली ओ पैसा देई बोली तापरे फॉरेस्टर मैडम दी शैडो विटनेस मुंड इसारा दल रे विजिलेंस स्टाफ सेटारे आसी गले तापरे सेमाने ये करियर सीबीपी मैडम को पर्पल कलर बैग रु सही टंका बाहरिला तापरे फॉरेस्टर मैडम शैडो विटनेस आसे धला पानी सीडीपी हाथ दे अलग अलग बुड़ाइले तार रंग गोलापी रंग हो गल दिस द स्टेटमेंट ऑन 64 of the decoy in indicating the petition.
There is evidence of acceptance, then under section 20 presumption operates against you. Is the rebuttable presumption, you have to face the trial to rebut that.
Your lordship, may I be allowed to submit something
Yes,
like
definitely.
Yes, your lordship. I have specifically mentioned in page number 10 and 12, 10 and 11 of my petition, Your Lordship. This is, there is no concept of postpaid bribe in PC Act. Your Lordship, on 6/9/2021, I have given all the relied document in Annexure 4 series, Your Lordship. 6/9/2021, Chatua bill was submitted. 7/9/2021, the accused verified the bill and transmitted. Your Lordship, accused is not the authority to pass the bill. It is a DSW who is the authority to pass the bill, Your Lordship. Now 17/9, DSW approved the bill. 20 September, District Treasury instructed the bank to make e-payment. 22/9/2021, the bill amount were deposited in the account of 2 SSG. 29/2029, they have already withdrawn the amount, and thereafter on 3/10/2021 they have lost the FIR saying that just to pass the Chatua bill for the month of September, the September 2021, the accused has demanded 80,000 to me. Your Lordship,
Mr. Padjoshi, that is your defense.
yes,
And
that
you
is
are-
my Your
You
Lordship.
have to
But
establish that in the trial.
yes,
So
I
it's the authority to pass the bill or not, and regard the capacities or not, or the these are two sir.
Because see, there are 164 statement, 161 statement, and Dokai customer has said something, you have accepted the money, and the tainted money is recovered from your bag, and all these things are there. It has to be, sorted out in the trial only.
But I have no objection with lordship allow that grant leave to my lunch time to raise all those defense in the trial. These are required
It should raise all the point at the appropriate stage in the trial.
my only submission, Your Lordship, is the allegation that is leveled against me. The CDPO is not the authority to pass the bill. Second, there is no postpaid concept of bribe in PC Act, just to attract Section 7 of PC Act, Your Lordship. That is my only submission.
This things has to be settled in the trial only.
Yes, Your Lordship. And
trial is becoming a charge. I don't think, sir. You just raise all those points, my lordship.
Yes, what do you say? Do you want an order, or just you will raise the points there in the trial court?
I'll raise the point. If there is a order from this honorable court in that respect.
Unnecessary, it is your, I will give some observation unnecessary that may cause some problem for you in the trial, therefore.
Yes.
That's what I'm saying.
Yes.
Learned counsel for the petitioner seeks leave of this court to withdraw this petition, reserving his right to raise all the point before the trial court at the appropriate stage.
Including his plea for the no authorities.
Including the plea, with this liberty, the petition is disposed of.
Your Lordship, and
Yes.
I may pray for the expedite disposal of the case in the
I don't know.
It's possible.
At this stage, Mr. A.K. Padjoshi, learned counsel for the petitioner submits that at least the trial, at least there should be a direction for the purpose of expedient disposal of the trial. Needless to say that the accused enjoys the statutory and constitutional right for free, fair, and speedy trial. That being so, the trial court is expected to do well to see that the trial is concluded quite expediently.
And I put on record my appreciation. My lunch was given a particular copy of the it includes all the documents.
Yes,
Mr.
Mrs. Das is a very senior prosecutor.
And he has not left any in placing all the
Very drafted.
now people are not finding the affair. Okay, now you have given all the
All the documents and all, I also appreciate for the same.
Much obliged, Your Lordship.
Keep doing it. Yes.
Item 7.
7 minutes.
Unusual petition. Everything is there.
and I need to just format the point very nice.
Very nice. This should be the level of the High Court pleadings and
Exactly, Mox. Exactly.
very nice. Yes.
7 million, this is the second bail application. And first bail application was withdrawn because that was the rejection order was before charge sheet. So, Your Lordship, I have after charge sheet, I have filed this bail application.
Yes.
So, here, my lord, custody period is 3/4/2024.
3/4/2024.
2024. Okay.
3/4/24. Okay.
And offense is 376(2) and both are major, my lord, the informant and the petitioner, and both are married also. And I have also annexed, died annexed to
What is the age of the
age of the victim is 35 years.
age of the 164?
After the CD my lord, 155 listed my lord, but he has given me 164.
Yes. See, read it. Is there any?
my lord, ମୋର ତାର ସଞ୍ଜୟ ପରିଚୟ ସହ ଗତ ବର୍ଷେ ପୂର୍ବରୁ ଆମ ଗାଁରେ ଦେଖା ହୋଇଥିଲା। ମୋର ତା ଫୋନରେ କଥା ବାର୍ତ୍ତାଳାପ ହେଲୁ। ସେ ମତେ ବାହା ବୋଲି କହିଲା। ମୁଁ ଜଣେ ବିଧବା ହୋଇଥିବାରୁ ପ୍ରଥମେ ମନା କଲି, କିନ୍ତୁ ମତେ ସେ ରାଜି କରାଇଲେ। 2023 ମସିହାରେ ଗତ 2023 ମସିହାରେ ସେ ମତେ ଚେନ୍ନାଇ ନେଇଗଲେ। ସେଠି ଘର ଭଡା ନେଇ ଏକାଠି ରହିଲୁ, ମିଶି କାମ କରିଲୁ। ତାପରେ 5 ମାସ ରହିଲା ଭିତରେ ସେ ମତେ ବାହା ହେଇ ଶଙ୍ଖା ସିନ୍ଦୁର ଦେଲେ। ମୋ ସହ ବିଭିନ୍ନ
He also stated that the petitioner has married with her and stayed for 5 months. However, while returning from Chennai, and the petitioner
physical relationship Chennai
while returning from the Chennai, on the way, the petitioner alleged to have taken 30,000 rupees and deserted the victim.
gold ornaments.
Old gold, 30,000 and old ornament, and deserted the victim. Petitioner is in custody since 3/4/2024.
34. 38. 38th April.
3/4/2024. Regarding head to the period of custody and the nature of allegation against the petitioner, I'm inclined to enlarge the petition on bail. Charge sheet has been filed, huh?
Charge sheet filed.
Charge sheet in this case is also
Charge sheet filed on 26/6/2024.
charge sheet filed. Yes.
Obliged.
8 my lord, Ganjar 190 grams, but he had entering bail and not delayed surrender my lord.
Petitioner was entering bail dated.
Interdicted my lord.
But by C 14/24.
2/5, huh? Entering bail was 14/12/2023 and
2 hours there my lord, verify my lord.
8 minutes for a period of
45/2024 and 27/2023 order ଅଛି ଧୀରେ ଦେଖିଲେ
कितने दिन पहले निकला भाई?
once my lord.
For 2 months. Even after expiry of period
14/5/2024 my lord.
Period even after the expiry of the interim bail period, the petitioner appears to have not surrendered. The learned counsel for the petitioner who is appearing appearing for him states that he has no instruction.
My lord.
He has no instruction regarding to the aforementioned. The present petition is dismissed and the trial court is directed to issue appropriate process to ensure the presence of the petitioner accused for taking the trial. With this observation, the petition is dismissed. Yes.
I told my on behalf of Mr. Pramod Kumar Das, my lord, to then file for interim bail, my lord.
Service is complete. Huh? What is this going on? I am dismissing it and you do whatever.
And I know.
See, notice was issued on 26/7/2024. You did not file the looking deed. And the matter was taken up on 13/8/2024. You said that I have not filed requisite, I'll file it. I gave the time. Again, you didn't file requisite. I'm here only to it's the clerical job.
I prefer on behalf of Mr. Pramod Kumar Das.
No, whatever, I am dismissing right now. The
Madam, urban money or short urban and to instruction, madam.
you
Madam, one chance, madam.
when this matter is pending, how many hearing has taken place?
One chance, madam. One chance, madam.
There is no.
I prefer one chance, madam. Last chance, madam.
Don't deserve it.
Last chance, madam.
Offences are so serious, right? By the order dated 8/12/2023, notice was issued to opposite party number 2.
Madam, I prefer one chance to find a request, madam. Last chance, madam.
6 cents.
On 8/11/2023, the petitioner was directed to serve the extra copies on the council for the state. Through IIC,
I'm ready to purchase 25/2023 रे connection with above bill appeal number extra copy of notice not been served the
Yes.
copy notice could not be did not be served.
On for the purpose of serving the opposite party number 2 through the IIC, however, the same was not complied. When the matter was taken up on 24/4/2024, none appeared for the petitioner. Therefore, in the interest of justice, the matter was adjourned. Subsequently, on 26/7/2024, the
Ordinate bench.
The petitioner changed his counsel and sought adjournment. The matter was adjourned. And subsequent thereto, on 13/8/2024, again the counsel for the petitioner sought for time to file the postal requisite so as to serve opposite party number 2. When the matter is taken up today, again time is being the counsel for the petitioner is seeking an adjournment. No step has been taken by the petitioner for serving the opposite party number 2. Even the extra copy of the notice has not been received. Mr. Ragada has placed on record the instruction received from IIC MOTU regarding the same, which indicates that due to want of extra copies, the IIC could not serve the opposite party number 2. In view of the same, I am not inclined to entertain this petition. And
one chance, one chance to do.
However, liberty is granted to petitioner to renew the bail fee before the trial court. Yes, next.
Item 10.
Hello, last chance proper one chance.
Bound to impose cost. Don't take high court so lightly. We are working day and that they have to dispose of the matter. So you can't take the high court so lightly. What is this going on? 9 hearings.
Yes.
You don't have requisites.
Yeah, subsequently changes their.
You face it. I have given liberty, you move. There is no residue kata. You will move an application there.
One chance.
Get it rejected and again come. Who stopped you? Yes.
Item 10. May I please?
Yes.
Today I'm filing fresh VNA, my lords. Yeah. Filing fresh VNA, my lords.
Yes.
Fresh V. Wakalatnama.
It is called for.
CD is there, my lord. CD is there.
In fact, you are appealing for whom?
For the petitioner.
Consenting the.
Consent. Council consent.
As you have given Mr. Okay.
He has already.
Mr. Bageshwar Behra and associates have entered appearance on behalf of the petitioner by taking consent from the earlier counsel. The Vokalatnama is taken on record and release the matter after vacation. Okay. Yes.
Item 13.
11.
11 plus
11.
Agent.
13.
13. Yes, Mr. Panda, you are appearing. 14.
I am for 14, my lord.
Okay. 13. Pass over, huh? Pass over.
14.
Well, offense is 395 and 25-27 Arms Act, and the petitioner is in custody since 23/8/23, more than 1 year, my lord.
23. Okay. Yes.
Age of the young age of 23 years.
1 minute. CD hasn't come immediately after vacation. Huh? Call for CD, leave the matter immediately after. Yes.
15.
May I please, yes.
Petitioner is custody matter. Petitioner is custody matter since 2011, 21, 29 to 21 matter.
Okay.
21/9,
You have given, which is the correct?
21/9 matter.
21/9,
2021 matter.
20. 21.
21 matter.
Yes.
Charges submitted matter under section 363, 366, 376, 2 and charges submitted matter 2011, 2021 matter.
Okay.
Yes, matter allotment, the 19 years and 70 years matter, they paid out and life different place matter. Thereafter, when returned to their village due to paucity of fund, thereafter the only allegation against the petitioner matter, 164 is there.
Let's see, 160.
But now 20, because 19 now is costed 2 years standing. So 1 matter, out of 25 witnesses, 12 has already been examined matter out of 25.
But see, he is 22-year-old. What did the girl say?
Yes, matter. May I read the 160 statement?
About 2 years he is already in custody.
More than may I read it? ମୁଁ ଆମକୁ ରହିକରି ଉପସ୍ଥିତ ହୋଇ ସତ୍ୟନାରାୟଣ ସତ୍ୟ ବୟାନ ଦଉଛି ଯେ ମୋର ପିଉସୀଙ୍କର ବାହାଘରକୁ ଯାଇଥିଲି, ସେଠାରେ ବଡପଣ୍ଡା ଗଣ୍ଡିର ଲିପୁଲ ରାଣା ସହ ମୁଁ ଦେଖା ହୋଇଥିଲା। ସେ ମତେ ମୋର 175 adulterated cough syrup.
Okay. What is the chemical examination report?
Chemical examination report. Chemical examination report.
Then comes for the date, seek 1 week time to obtain the instruction regarding the chemical analysis report. What is the, how much we need to leave the matter immediately after the investigation. Let us see what is the quantity. Correct. Yes.
Fast week.
Immediately. Yes.
18.
Yes, sir.
Last week, your lordship, as per my IA, my lord, your lordship directed to take instruction release of his mother.
You don't have a good case on merit for
Otherwise, my lord, out of total 22 succeeded witnesses, the 11 members prosecution witnesses already been examined, my lord. And regarding the 11 submitting regarding the IA, my lord, the health condition of the petitioner's mother, that has not been received, my lord. I have to tell
see,
you.
what I am proposing to do is, you get the information regarding the health condition. I'll grant 1 month interim bail. And insofar as main bail petition is concerned, I'll relegate him to trial court. Once he surrenders, he will surrender after 1 month and
for bail for the trial.
Regular bail there.
Yes, ma'am.
If the mother is not well, if the mother is not well,
His mother's case, no problem.
get it when 4th of
Yes, my lord, definitely.
4th. Mr. Rahul, let the counsel for the state
Yes,
wants to seek instruction regarding the health condition of the mother for the petitioner. For grant of interim bail, for grant of interim. Fourth, my lord. What are the, have you filed some prescription?
Yes. I will do that. It's a prescription, madam. Prescription.
You give the prescription.
Yes, I have already given.
Chest pain, 6 days.
No member is there, only mother is there.
Okay. What is the age of your mother?
Age the 56, my lord.
56, there is no disease at all. Chest pain, head drilling.
He is mad, my lord. He is moving here and there. No one
That take care. That should reflect in the medical report, and they will get.
let them take
Admission,
my lord.
Yes.
Yes.
Now only simply.
Same gastric. Pentaplows, drink lot of water and all.
ଗାଁ ଲୋକ ଆଜ୍ଞା ନେଇକି ତାକୁ ଟ୍ରିଟମେଣ୍ଟ କରେଇକି ଆଣିଛୁ ସେଇଟା ଦେଇଛୁ
You may get admission report. 19.
The petitioner is custody since 23/12/2022, my lord. 23/12/2022. The offence under section 341, 302, 307, 120B, 34 by PC.
4.
Yes, my lord.
Yes.
It is in the name not in the affair, my lord. And also the one of the eyewitness, 164 statement was recorded, has not stated anything about the petitioner, name of the petitioner. And she has also
Charge sheet filed.
charge sheet filed.
When?
Charge sheet.
When the charge sheet?
Yes, my lord. 9/4/2023.
9/4/2023. 24.
23. Oh, sir. 23.
Okay. Okay.
Only offence under section 120B against the present petitioner, my lord.
Yes.
Sibo Sankar Mishra. What happened, my lord? This petitioner was earlier in custody under the section 302. While he was in jail, my lord, and the appointments of the court, my lord, Hyderabad, the other time, the other petitioner, other two persons, they are moved to the court. And in the document, they are coming to the court. This petitioner has advised to the other fellows, those who are the hardened criminals, my lord, having all the different criminal antecedents, my lord. But he has suggested that the omnibus has written by you, target, or he is massive. This is the role of this petitioner in the custody, my lord, in the court campus. And the incident has been occurred, another three two have been there. One is deceased and another is seriously injured. That is Sibo right, and another is Sibo.
At the time of incident, he was in custody.
No, he was
Custody. Yes. And what the charge sheet file for offences?
Charge sheet file under offences, my lord, 302.
I mean, what else? 302 and?
My lord.
Only 302.
No, 34 120B.
Huh?
34 120.
120B is there. That's
Yes.
what I'm asking. 120B.
Yes.
What are the evidence? Who has heard that while he is giving instructions?
My lord, may I read one evidence heard? Confessional statement may be allowed to read.
Personal statement of who?
That's one of the accused, my lord. Sundaranjan Mahapatra, my lord. For that, your acceptance of the idea.
I got the idea, but what are the evidence you have? Only on the basis of confessional statement.
Confessional statement, my lord.
You have nothing. Then
No, my lord, admit that the evidences are available.
what evidence have you collected regarding that he has given instruction to kill? Because he was in custody.
Yes.
That time your allegation is he is the guy who has given instruction to these two people to kill someone. They have done it. And that you are inferring on the basis of the confessional statement of those two accused persons.
Because
Confessional statement you have collected.
my lord, as per the civil, my lord, this petitioner and along with other advocate persons in other model case, my lord, they are belongs to among good friend among each other, and they are
Any friend is my enemy.
my lord, that
That's the evidence you have.
I have to.
You just tell me whether he accepts the confessional statement of co-accused. Do you have any material against him? Maybe he is a dreaded criminal, but he's entitled to bail. You are not prepared, then let it be. Chapter के पढ़ो 500 के लिए, ठीक है? You please read it and because 302. 302. What happened to what happened in that case? Till you are in custody.
No, I will not there.
Take it up. Yes. 7-8. ठीक है. Yes.
20.
Your lordship, the petitioner is alleged to have committed offense under section 376(2) and 376(3) and 6 of the so petitioner is in custody before custody since 8th August 2023. Charge sheet has been submitted on 8th October 2023.
October.
8-10-2023.
Yes.
And 164 statement is at 1275, your lordship.
Yes. 75,
your lordship.
yes. Read it up.
ମୁଁ ଆଜି ଏଠାରେ ଉପସ୍ଥିତ ହୋଇ ଶପଥ ନେବା ପୂର୍ବକ ଏହି ସତ୍ୟ ବୟାନ ଦେଉଛି କି ମୁଁ 4-8-23 ସକାଳ 9ଟାରେ କଲେଜ ଯାଇଥିଲି। ସେଦିନ ମୁଁ ଯାହାକୁ ଭଲ ପାଏ ହେମନ୍ତ କୋର୍ଟ ମତେ ମୋ ଇଚ୍ଛା ନଥିଲେ ମଧ୍ୟ ରାଉରକେଲାକୁ ନେଇକି ଯାଇଥିଲା।
78 of what?
70 page, your lordship. 75 page.
5 page. Okay. Yes.
Page number 74, running page.
Yes. Yes, read it. What is the age of this girl?
16 years.
Yes.
In the date of occurrence, she was 15 years.
Okay.
And the present it is an age 28 years.
28 years today. No, that time.
On that day. 24. In 24,
Yes.
she was 20.
Read it.
ସେହି ସମୟ ସେ ମତେ ସ୍ୱସ୍ତିକ ଲଜରେ ରଖିଲା। ସେଠି 2 ଦିନ ରହିଲୁ। 4-8-23 ଓ 5-8-23 ରହିଲୁ। 5-8-23 ରାତି 7ଟାରେ ଆମେ ଟ୍ରେନରେ ଆସି ସମ୍ବଲପୁର ଆସିଲୁ। ସମ୍ବଲପୁର ରେଲୱେ ଷ୍ଟେସନରେ 6-8-23 ଓ 7-8-23 ରହିଲୁ। ସେ ହେମନ୍ତ ମତେ ରାଉରକେଲା ଯିବା ଓ ମୋ ସହ ଜୋର ଜବରଦସ୍ତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା। 8-23 ଦିନ 6ଟି ଇନଷ୍ଟ୍ରକ୍ସନ whether there is
No. Tell her to appear through VC. Tell her to appear through VC. By the order dated 17/9/2024, the victim and the informant were served through the IO, but none appears for them. Let the victim and informant present in the court through IO, along with IO through virtual mode on. They do. Vacation game is it?
Also, put a software this level. This one,
Yes. This one.
at least 30th, your lordship.
23rd
Fifth Saturday, working day this time.
Yes, your lordship. 50 working day. Yes, 50 working day. Yes, 50 working day, your lordship. हाँ वर्किंग डे हमने तो नहीं थी जो छोटी सा एडमिनिस्ट्रेटर कराई थी 5 लाख
Chairman, under section 13(1) CD, PC Act and 20934 IPC. Chairman, your lordship 5 cases before lordship my lord.
What, Mr. Patel, you are a leader, your voice is not to be. Leader means you should speak so loudly that everybody could hear. Depending on them. Then he doesn't have a good case. So that is the reason. Speaking so slowly. Yes.
Again, to this scenario, ex-video my lord. He is in custody, my lord.
Yes.
23/8/2023. Yes, my lord.
23, okay.
And my son is here, my lord, 5 cases before lordship, my lord. In 5 cases, my lord, that is the allegation of misapprehension of, in first cases, my lord, 5 lakhs, my lord. To second number cases, 5 lakhs, my lord. And
how many cases you have?
5 cases, my lord, before lordship.
Proceedings and like last to the order, last order 12 है. 12 8 है. I had filed one appraisal report of the SP Vigilance Hon'Ble Korapur. Your Lordship, your Lordship go through the same, your Lordship last para. For 9 years, this accused absconded even the service. Absconded for 9 years and we apprehended him daily. And accused my lord, we made the job. We don't any need him. And we sought with much difficulty we found him. After 7 cases, in one case he has been convicted, filed the appeal before this honorable court. Another case, he has been granted bail, and these 5 cases are given the status of the 6 cases. In one case, he has been convicted.
In this case, charge it well, charge it you.
Yes. All the cases charge sheet has been filed. I have given details, my lord. Your lordship may have a glance. When I am how many witnesses have been examined. My prayer that आज एक से charge sheet filing थी, कोई से 2024 रे.
Yes.
कोई से 2024 रे.
The conduct is you have seen.
Already, I mean, in the 9 years.
You are out.
Yes.
And you are in a video.
I was going so I similar.
You spend little time so that
I was similar.
you will be convicted, sentenced for 3-4 years.
Okay, any condition will run currently. My sole prayer is that again, this may age about 65 years old. 1 year is already considered. Only 23 lakhs. One case already.
How many cases you have already got bail?
6.
Got bail?
We have 2 cases.
2 cases.
2 cases. And my cases is total 20 lakhs in Shah.
You filed an affidavit.
Already filed.
File affidavit. Where no copy of your will?
No,
which affidavit?
which affidavit? No, blanks. Already I have filed. That is already filed. My friend filed.
Where is that?
Only the cases number and the record.
Give particulars.
Those matter I know I place for the check.
And like this.
There are 2 matter. I have given how many witnesses are there? My senior
How many witnesses are there in this case?
in it actually it's out and examined. No, so not. 23 9 have been examined. Third is it out of 23 3 witnesses have been examined. Case number 4 3 witnesses have been examined. And last 2 charges has been filed. All the
cases she is in custody from 23rd.
Thereafter, you remanded in all these cases.
Okay.
And in facing the trial, similar similar. You also kindly see annexure and कोई भी माला you only videos you are no some of those don't mention of the case that don't mention the what kind of city what is the order so it's 30 mala in which case the first case mala
First case. 38, huh?
Yes. 39 is order mala
269.
I'm on the Mala. A similar thing is similar granted both. Allegation saman, these are separate question one way. Today, like it was granted a Mala. 1 year custody, presentation over 65 years Mala.
ବିଭିନ୍ନ ଟାଇମରେ ବିଭିନ୍ନ ଟଙ୍କା ନେଇଛନ୍ତି ଖାଲି
ହଁ ସେତିକି ଯେତିକି ହେଇଛି ସେତେ ଦେବି ନା ଆଉ କଣ ଏଇ ଭିଡିଓ ମରିଯିବା ଟାଇମ ଆପଣ ଡିଫରେଣ୍ଟ କହିଲେ ଆପଣ ମଲେ ଆପଣ
directed to the co-accused was directed
ଆମେ ତ ନା ନା ଏଇଟା 23 ନମ୍ବର ଇଣ୍ଟରସିପେବଲ ହେଇଯିବ ଆପଣ
you file a detailed affidavit and put it in fifth. And tell me what are the conditions.
And clarification.
I have filed how many witnesses?
Let him.
How can, yeah, that's actually within kind.
She co-accused has already been granted.
Yes, my lord.
No, one co-accused has been granted.
Listen to me. Co-accused has already been granted bail. He is in custody since more than 1 year.
Yes.
He is about 65 years of age. These are the Prevention of Corruption Act. Earlier Prevention of Corruption Act, they used to be granted bail there and then.
Yes, sir.
No, my lord. I will also found this.
That is why we will appear in the police station.
हाँ.
Go with the vigilance officer. Every Sunday you go and
Let him file the affidavit that
that is why I am asking. He has to disclose everything.
this may be kept in the record, my lord.
And what are the other conditions you want? All those things we will.
No, deduction छाड़ी की दूँगी, कोरा फिर deduction छाड़ी की दूँगा.
Now so you will say everything. There are no.
Any chance?
No, violation of one single opportunity, single violation will entail the cancellation. Everything will see. Sunday you give all the Saturday, 5th. I'm listing this matter on 5th. You do.
On 5th, witnesses will to examine the charge in detail.
Therefore, you give me the conditions, whatever condition you want, you give on 5th.
Yes.
And you give file an affidavit.
Yes, my lord.
Affidavit giving an undertaking that you will not leave the jurisdiction for the Koraput.
Yes.
Till the trial, trial of all the cases.
On each and every date of posting of each case, he should
One absence will be cancelled.
Yes.
All this condition. These things has to be written in your affidavit. So if you don't write the affidavit, I'll reject the affidavit.
No, करते.
Now that being one line affidavit.
आगे साढ़े 4 तारीख चाहूँ हाँ तो 4 तारीख का चाहूँ ना वाला काम है 4 तारीख
सर ये ना वो कोरापुट राइड में ना इंस्ट्रक्शन
4 तारीख 5 तारीख 4 तारीख
Time not there.
5 तारीख
चलो मैं चलो 7 तारीख को अभी बाहर रही है
7. Let me 7.
हाँ अब आओ दिन दिल्ली
So then the 8th the Lord is fixing on 7th now
8. Affidavit would be exhaustive. I am granting bail subject to condition that you file a better affidavit.
affidavit along with the undertaking to
Undertaking everything here.
Yeah.
And all the 5 cases, huh?
Yes. And also, I will pray for cash security to be deposited.
Yes.
22.
Yes, 22.
A memo was filed for withdrawal.
Withdraw, huh? Yes, 22 withdraw. Yes. Huh? What happened? 5-9? One 60-70. Where is how he got the second accused got the bail? When the matter was pending, he got the bail. Pending before this court. There are 2 accused persons. One of them has been released under 167(2), no problem. And insofar as the other accused person is concerned, he has been enlarged on bail.
But other accused person is Somyaranjan Goda.
How he got the bail?
Somyaranjan Goda has
Lambodar Goda.
Lambodar is not the petitioner again. Niranjan and Somya.
Lambodar Goda is written. Lambodar Goda. Who is appearing?
Niranjan Goda also on bail.
Yes. You Somyaranjan also got bail.
No, Niranjan Goda also on bail.
And what about who is Lambodar then?
Lambodar previous first accused who got the bail under section 167(2).
Okay, Lambodar is not in.
Damodar is not here. Damodar
You want to withdraw it?
Huh.
Yes. Withdraw. Yes.
23.
May I please your lordship and be safe.
Yes.
Item 23.
Yes.
But the petitioner got charge sheeted under section 306 IPC. Last occasion, my lord was pleased to direct because there was a honorable coordinated bench directed to call for the CD and all that. Last occasion, my lord directed State Council to
CD
bring the records, as well as I have filed the charge sheet of the entire
This order was made. At that time, their offense was 302. In the charge sheet value, it was 306. So let it renew his prayer before the court.
And custody since not
See now.
19/5/2004.
1 minute. See, when your bail application was rejected on 20th April 2024, subsequently charge sheet has been filed on 306.
6, my lord.
When it was
Last
rejected
occasion,
that
this
time, it was 302.
I just apprised your lordship. Last occasion, my lord was convinced that once formally case diary may be called for because coordinator was directed to consider.
CD affidavit. To CD today.
So once charge sheet, you will also be
You
considered.
are in custody- you tell me you are in custody since?
My 21.
Since 19/5/2024.
19/5, 21.
Sorry, 21st March 2024.
23.
21st 21st March.
21st March. What are the evidences?
No evidence
Which fragment?
allegation. As accused was Millard asking money. Deceased consumed Millard some poison. It's the charge sheet. Last but 2 lines. Millard
Poison part.
he consumed some poison pesticide which is available in her home. Immediately she was shifted to CHE Badamba for treatment.
Who accepted you?
No, Millard, the DC is shifted.
The allegation is that there is a monetary transaction between the deceased and the present petitioner.
It's not the husband. They have
No husband.
Yes.
And the death is due to poison. And viscera was kept reserved.
He was there. He was there in the place of taking poison when he took poison.
No. It was not present.
Then
My own instigation part, that one Kajal Das, who is the daughter of the deceased, she has stated, I am reading some question,
yes.
ଯେ ମୋ ବୋଉ ସାଙ୍ଗରେ ମୁଁ ସିଂହନାଥ ମନ୍ଦିର ଯାଇଥିଲି ସମୟ 6ଟା ହେବ ମନ୍ଦିରରେ ଛିଡା ହୋଇଥିବା ସମୟରେ ଦିଲ୍ଲୀପ ମଲ୍ଲିକ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ମୋ ବୋଉକୁ ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କରି ମତେ ବାହା ହେବ ବୋଲି କହି ବହୁତ ଖରାପ ଭାଷାରେ ଗାଳି ଦେଲା ମୋ ବୋଉ ତା ପ୍ରତିବାଦ କରି ପାଟିତୁଣ୍ଡ କରିବା ପାଇଁ ନ କରିବା ପାଇଁ କହିଲା କିନ୍ତୁ ମୋ ବୋଉକୁ ସବୁବେଳେ ଧମକ ଦେଉଥିଲା କି ସେ ମତେ ବାହା ହେବ ଯଦି ମୋର ବୋଉ କି ବାପା ତାର କଥାରେ ରାଜି ନହନ୍ତି ସେ ମତେ ଜବରଦସ୍ତ ଘରୁ ଉଠାଇ ନେବ ବୋଲି ଧମକ ଦେଉଥିଲା ସେଇ ଭୟରେ ମୋ ବୋଉ ମତେ କଲେଜ ଯିବା ପାଇଁ ମନା କରିଲା ଏବଂ ସେଥିପାଇଁ ମୁଁ ଡରରେ ମୁଁ କଲେଜକୁ ପାଠ ପଢିବା ପାଇଁ ଯାଉନଥିଲି ଗତ 13/3/24 ର ଘଟଣା ଦିନ 2:30 ମୁଁ ବାଟ ପାଖ ଘର ପାଖରେ ଶୋଇଥିଲି ମୋ ବୋଉ ଆର ଘରେ ଥିଲା ମୁଁ ହଠାତ୍ ମୋ ବୋଉର ପାଟି ଶୁଣି ଯାଇ ଦେଖିଲି ଯେ ମୋର ବୋଉ ବାନ୍ତି କରୁଥିଲା ସେଟାରେ ଆମ ଘରେ ଚାଉଳ ଡବାରେ ଥିବା ପୋକମରା ଔଷଧ ଜରି ଓ ଗୋଟିଏ ଷ୍ଟିଲ ଗ୍ଲାସ ପଡିଥିଲା ମୁଁ ମୋ ବୋଉକୁ ପଚାରିବାରୁ ମୋର ବୋଉ କହିଲା କି ମତେ ଦିଲ୍ଲୀପ ବହୁତ ହଇରାଣ କରିଥିବାରୁ ମୁଁ ତାର ନିର୍ଯାତନା ସହି ନ ପାରି ଘରେ ଚାଉଳ ଡବାରେ ଥିବା ପୋକମରା ଔଷଧକୁ ପିଇ ଦେଇଛି
Judgment, Priyanka.
He was not present there.
You were not present. There were some
Financial
transaction. The evidence, the statement of the witnesses recorded at the page under section 161 CRPC was read about extensively. And from the allegations from the evidence, it reveals that there was some financial dealing between the petitioner and the deceased. The petitioner appears to have been harassing on the demand of written approach financial. Petitioner alleged to have been harassing the deceased. On the what is the date? On which date she committed suicide? Which date she committed suicide? On
that is on
13/3.
13/3/2024. 13/3/23. On
24 man. 13/3/24.
2024. The deceased appears to have consumed poison which was available in the house. What was that?
Pesticides poison.
consumed pesticide, which was in her house, it was used of which she died despite the efforts were made to save her by taking to the hospital. Next petition is in custody since 21/3/2008. Regarding head to the initially the FIR was registered for offence under section 302 IPC. 302 and other allied offences. However, after investigation, the charge sheet has been filed for alleged offence under section 306 and allied offence. Regarding head to the period of custody from 21/3/2024 and the nature of allegation. Acquisition. I am inclined to enlarge the petition on bail according to granted bail.
But in the meantime, ST case been 100.
It only on 306, not other allegations of offences. Only 306.
And ST case number 100 of 2024.
Nice, season over what कहते हैं.
आगे.
ना ना
रगड़ भाई ठीक है କହିଦେବେ ST case 100 mo ki associate बोधे अन्य कोर्ट रही जल्दी
हां जान
ST 124
हां से excellent
ଆଉ pending in the court of additional session judge Atagad करे ଟିକେ kindly ମୋ पे help करियो ठीक है
ST
100/24
100/24
हां 24 ଆଉ pending in the court of additional session judge Atagad additional session judge Atagad Atagad ଏବେ charge frame ହେଇକି ପଳିଛି thank you संग्राम thank you
Yes.
When the one Kalucharan Pradhan, who was present at that time, already was terminated and seizure witness that income of offence from the seized on the instance of the petitioner, he was also terminated. Where also kindly produced.
This is 302, 120, 109 and 27 as per charge sheet was submitted. And injury matter, there is 21 numbers of injury as there.
Eyewitness is there.
Not eyewitness, no eyewitness there.
27 you have
27 disclosure leading to discovery
and the reconciliation cases have
I am that the knife was seized from the present petitioner and sword was seized from the spot. There was a CDR report is my lord there. This is present petitioner. Another co-accused person who is item 26. Here both are under the same tower and they were talk with the present petitioner and another co-accused, they have talk each other at the same time. This is a CDR report. And then my lord, one I am reading the
what the time difference?
My lord?
Time difference. The incident and the CDR report.
That is CDR report he has provided. Differently they have talked with each other. That is before. And my one Bhagavan Pradhan, who is a pre-occurrence witnesses. I'm reading his statement, my lord.
Yes.
ଯେ ମୁଁ ଆଜି ବୟାନ ଦଉଛି କି ପ୍ରାୟ 8ଟା ବେଳେ ଆମ ଗ୍ରାମର ପୋକ ମହାନ୍ତି ପାନ ଦୋକାନରେ ଥିଲା ପୋକ ମହାନ୍ତି ମାଇ ଲର୍ଡ ଇଜ ଦ ଡିସିଜ୍ଡ ତାପରେ ସେ ତାର ସ୍କୁଟି ଧରି ଉକୁଡାପଟ ଗ୍ରାମ ରାସ୍ତାରେ ଗଲା ସେ ଯିବା ପରେ ଆମ ଗ୍ରାମର ସଞ୍ଜୟ ପଲାଇ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଶ୍ରୀଧର ନାୟକ ଆନଦର କୋଆକ୍ୟୁଜ ଇନ ଆଇଟମ 26 କିଛି ସମୟ କଥା ହେଲେ ଓ ସଞ୍ଜୟ କୁମାର ପଲାଇ ଗୋଟିଏ ଖଣ୍ଡା ଶ୍ରୀଧର ନାୟକକୁ ଦେଲା ଏହାପରେ ସଞ୍ଜୟ କୁମାର ପଲାଇ ଉକୁଡାପଟ ଗ୍ରାମ ରାସ୍ତାରେ ଗଲା ଏବଂ ତାର ପଛପଟେ ଶ୍ରୀଧର ନାୟକ ଖଣ୍ଡାଟିକୁ ଧରି ଯାଇ କଳା ପାଖ ବୁଲାଣି ରାସ୍ତାରେ ସେ ଖଣ୍ଡାଟିକୁ ସଞ୍ଜୟ ପଲାଇକୁ ଦେଲା ଏହାର କିଛି ସମୟ ପରେ ଅର୍ଥାତ 11ଟା ବେଳେ ମୁଁ ଶୁଣିଲି ଯେ ପୋକ ମହାନ୍ତିକୁ ଉକୁଡାପଟ ଗ୍ରାମ ରାସ୍ତା ମଧ୍ୟରେ କିଏ ହାଣି ଦେଇଛି so pre-occurrence they have hold the
witness has already been examined.
No, not examined. Another matter before whom the present petitioner made extrajudicial confession. That was his 164 statement. Matter I am reading.
And he is not examined.
He is not examined.
But the first witness name, what is the first witness name?
My first witness he has seen that the
name.
My lord, his name is, my lord, Bhagavan Pradhan.
Bhagavan.
My lord.
Yes. And
Another matter is Babu Gowda.
Babu?
Gowda.
Gowda.
Gowda. G-O-V-D.
Oh. Extra.
Recorded section 164.
Yes.
ସେଦିନ ରାତ୍ର 10ଟା 55 ସମୟରେ ସଞ୍ଜୟ ପଲାଇ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ମତେ ଫୋନ କରି କହିଲେ କି ସିଏ କୋକନାକୁ ମାରିଦେଲେ।
So let these two.
No, your lordship kindly consider, my lord, that Bhagavan Pradhan is concerned that is hearsay evidence, my lord.
No, you have seen it. In incident, he has not seen, but you are holding the gun and passing on to your co-accused. He has seen it.
And that is from the spot.
And
your lordship kindly furnish the evidence, my lord.
The seizure is not proved, but these two witnesses have to be examined.
So far as the next 26 item, he is not assaulted.
Both the matters.
No, your lordship kindly consider so far as the 26 is concerned. One allegation. There is no allegation. Allegation against the petitioner 24, my lord, but somebody is concerned.
What is the evidence against this? Sridhar?
Sridhar 120 allegation.
Yes, Sridhar. Sridhar, my lord, there is CDA and there is a pre-occurrence witnesses stated that he has handed over sworn to the. Apart from this, my lord, against that present that Sridhar, there is one antecedent under section of NDPS Act.
See,
let
your lordship kindly consider
25, 26. You have already antecedent. These two.
Antecedent is
The problem is there are two witnesses and 302 arms act and everything is there.
120 allegation evidence for
I'm giving.
kindly consider, my lord.
How many witnesses are there total? Total witnesses?
My lord,
these two witnesses, apart from that, who all are there?
45 witnesses are there, my lord.
yes, my lord, 45 witnesses. Let these two witnesses be examined.
Your lordship, one may be considered, my lord.
Witnesses to be examined within 3 months and thereafter.
Your lordship, one may be considered, item 26 is 120 and one may be custody, my lord.
6 and 25 and 26. The petition is taken to the FIR. Regarding had to the evidence of one Bhagavan, only Bhagavan. And Bapu God. Bhagavan was Bapu God was read over. The statement recorded on 161 and 164. Bapu God was read over. He is the witness to the extrajudicial conflict. Insofar as the Bhagavan God statement is concerned, and Bhagavan God is concerned, and then he is the witness to the pre-occurrence. He is the pre-occurrence witness. However, after the examination, these two, the aforementioned two witnesses, namely Bhagavan and Bapu Godo. The trial court is directed to examine these two witnesses, give preference over other witnesses within 3 months hence. 3 months hence. And
3 months hence, your lordship.
3 months. Hence. And
time is continuing that so.
Therefore, I am saying 3 months hence, and thereafter the petitioner may renew their bail. If such bail fee is renewed, the same shall be considered on the basis of the material available on record then. Yes. 26 and
25.
Yes.
Both the cases for
both. Yeah. 3 months.
Yeah, 3 judgments.
7. 25 होगी ना?
24, 26.
24 and 26. Okay. 24 and 26. Sorry. Yes. 25.
Applicable to 307, my lord. Petition in question 6424, my lord.
6424.
Case already committed, my lord.
Yes.
2019 matter.
मतलब petitioner got anti-suitable mailing that yes, my lord, petitioner got anti-suitable mailing 2020, my lord. I have quoted in paragraph 5, my lord. Okay, you got anti-suitable thereafter you. Yes, my lord, you got anti-suitable, my lord, including my lord. And the case was disposed upon 6/4/24, my lord. Yes, sorry, case was disposed upon 19/4/2020, my lord. Where is it? My lord. There are conducted advocate has not intimated the where have you said where is that order? Yes, I have stated in paragraph 5, my lord. 5, okay. Yes.
Anticipatable allowed.
No. Disposal of no. And he got the interim bail, thereafter it was disposed of. When was it disposed of? Bail chart 24/4/24. Where is that order? The order is not with me, my lord. You can download and tell me whatever. Disposal of 19/4/2020. Disposal of why? It is dismissed. Dismissed, my lord. On merits. On merits, my lord. Are you sure? Yes, my lord. Where is that order? So order now download करके ना देखियो ना पासवर्ड कुछ दियो. Yes, download करके आना तू. Yes, देखियो. Merit if any comment is made or something, I don't know. Let us see. Shall I put it on Friday? Shall I put it on Friday? Yes, my lord, Friday. Monday, Tuesday, third. Get that order, third. Friday, third. Friday, see, Friday there will be reference and all, maybe problem. So therefore.
27.
27 is not.
Chiri.
376 AB, and he also not filed the review.
File the course of the way. Both the parties are default. In course of the day,
Mr. Chand submit that he would be filing in court requisition in 2 days. 2 days. And meanwhile, the CD may be obtained by the state council. Please matter. Takes.
28.
May I please? Custody since 12/12/23, my lord. 12/12/2022, my lord.
22.
Charge sheet submitted 22/2/23, my lord, for the offence under section 302/506. 22/2/23.
Okay. Yes.
And charge sheet, my lord, the case is that they both are related to each other, my lord, cousin brothers, my lord. There is a civil dispute. On the date of occurrence, there extract stone from the field, my lord. There is a dispute between the petitioner and the deceased, my lord. Thereafter, the deceased called the petitioner over phone and scolded, my lord. Thereafter, he challenged that.
What is the FIR number? What are the particulars FIR?
The FIR is my lord on 12/12/22. 12/12/22.
What is the number of FIR?
260.
260 of 2022. You have not annexed.
Where from you got it?
That is in our case diary, but he has not annexed it.
Why don't you file the FIR? At least they should file it.
Because number to have a defect number on the whole difficult.
The problem I'll tell you, if I'll grant the bail, FIR number is not there, you will write something else.
No.
Thereafter you move application, all these things happen.
First title or should be assumed.
Why should I believe? Whatever you write, why should I believe? Suppose the FIR which number you have written in the application, in the offences are very smaller offence. I'll grant the bail. Subsequently move an application in the 302. I'll correct the FIR number. Then what will happen?
The rejection order, FIR number. Yes.
FIR is minimum. At least one should know what is the case. And in the rejection order, there is no FIR number.
Yes.
Where is that?
First line.
Rejection order? ST number is 6. ST number is there.
No. Ghatwa PS case number 260 of.
Where is that?
Above my lord. Copy of order passed by the London District Session. Above person. Top of the.
ST number.
No, my lord. That is Ghatwa PS case.
The arising order. Yes.
Arising order.
You have to search, research for that. Okay. Yes, what are the allegations?
And thereafter the present petitioner came and assaulted by means of stone. That is the allegation, and one injury
offences are
302, my lord, purchase committed under section 302 and assaulted by means of a stone to the head, my lord. And the injuries on the frontal bone side and the parietal side. And some of the witnesses were examined. Out of 23
I have
witnesses.
the
Eyewitness who is the wife of the deceased, she was not yet been examined.
Not examined.
No, my lord. And another my eyewitnesses who is a carpenter who was doing work on that day in the deceased house. He was examined at PW 6.
Yes.
He has annexed my lord, can you see para 2?
PW 6, huh?
Page 22.
22.
My lord.
Yes, read it.
The occurrence took place on 12/12/22 at 2 p.m. in the house of the deceased Niranjana Giri. On that day, at the time of occurrence, I was in the house of the deceased and taking my food. The phone of the deceased Niranjana Giri rang and he talked to someone, and when his wife asked, he stated that it was the accused coroner who had called him. And thereafter, both the deceased and his
What is your name? Corona.
coroner and his wife talked about some land dispute between the accused and the deceased. All of a sudden, the wife of the deceased called me saying, Mr. Budhapu, Corona, Pitipokela. I immediately came and saw the accused assaulting to the head of the deceased by means of a stone. I ran and called to the person living in front of the house of the deceased. The nearby people came and called the ambulance. The deceased was shifted to hospital where he died, my lord.
How will you get out of it? Direct evidence.
My lord.
And 302 is that it is with the intention that to assault.
There are disputes, there were disputes, therefore he attacked. Direct evidence.
Para 8 in the my lord, cross, my lord.
18.
8.
8, huh? Okay. The fact that I have stated before the magistrate when the statement was recorded.
So when my statement recorded, the district talking in the phone slowly.
All of a sudden he shouted saying so and so and so and so overhead, and the fact that I have stated before the magistrate that my statement was recorded that after the phone was all that. What do you want to say?
That is the confirmation of 164. That is
nothing.
But he has not. I went and saw the deceased had sustained bleeding injury. That is, he stated that in the
one line somewhere you can't read it in the entirety. Entirety. He has stated those things before the police under 161. He said
yes,
and he repeated the same thing here.
And in the I went and saw the deceased was in the
who is the wife of
Rukumani Giri. May I please Rukumani Giri not examining the
matter. I'm saying that after that statement. Rukumani Giri,
wife of the deceased.
The wife of the deceased, wife of the petitioner.
No.
Wife of the deceased, Rukumani Giri, has not yet been examined. And who is a vital witness?
Eyewitness.
Vital witness of the prosecution. Therefore, the petitioner may renew the bail plea after the vital witnesses are examined. With this liberty, the petitioner is disposed of. Yes.
29.
May I please on behalf of Mr. Mishra?
Yes, sir.
Petitioner is in custody orders 19/4/24. 19/4/24.
4/24. Okay.
24. Charge sheet has been filed on 11/7/24.
11/7.
For the offence lodged
23rd of April 2020.
Let's see if he is entitled to bail, I'll give. Otherwise, I'll send you.
One quintal,
60 kg each.
60 kilo.
60 kg each, two petitioners, 120 kg total has been recovered from the possession of
Renew the bail plea. Lost the 100. Side of petition is agreed by the order dated 23/4/2024. Petitioners are agreed by the order dated 23/4/2024. Whereby their bail application has been rejected. It is alleged that 120 kilo of contraband ganja has been recovered from both of them.
Both separate motorbike.
Being carried by them in a separate motorcycle. Separate motorcycle. Then counsel for the petitioner submit that each of them were carrying 60 kilo of contraband ganja. Subsequently, on 11/7/2024, charge sheet in the present case has been filed. Regard being had to the fact that the charge sheet has been filed pursuant to the indication of the bail plea,
On the changing circumstances, petitioner are given liberty to renew the bail plea before the trial court. If such bail plea is moved, the same shall be considered on the basis of the material form part of the charge sheet. To this liberty, petition is disposed of. Yes. Next.
May I please?
Yes, boy. 17 years girl.
Okay, 306. Shall have been allowed to go on in
Fully come as
So, order to look. So, automatically baby is I don't know. It is not waiting for that only I'm saying.
let the CD come without CD. CD.
But Friday,
Not Friday. We can't get the CD.
CD is there in the last week when it was allowed.
I don't know.
Yes. So,
Give the number of.
I'll give you the order.
If the CD is there, then okay. Fifth. Yes, fifth. Yes.
Wait, please, Your Honor.
Yes, sir.
With peculiar case, the petition for my lord is in custody since 20th April 2024. But here is a case. My lord, informant is the wife of the deceased, and name of the deceased is Arun Kumar Raut, my lord. The way the occurrence has taken place, I am just reading one statement. I think all the statements are the similar nature, similar way, my lord.
Yes.
Statement of one Prahalad Panda. My lord, let me kindly see it instead of it will be better. Certified copy. I have given the copy to my lord and friend. Yes, yes. Oh, so it's not a ground to. My lord, may kindly see.
If he is entitled to bail, I'll give. Otherwise, I'll carry. CD is there.
Yes, sir.
Let us see. Okay. Currently, if the case is made out, then only I'll give.
Hello.
What do you want to say? Yeah, from here, what do you want to say?
My lord, the CD statement, my lord, see under what circumstances this occurrence has taken place.
Arun Kumar Pedda is Prodipto.
And all the statements are in a similar way.
I would not have the rules.
I would just statement which. It seems that the entire case, no intention was there to do away with the life.
Arun Raut is the
Deceased, my lord.
deceased.
It cannot be ascertained that no intention, no motive, nothing is there. Or preparation was also there to commit murder. That pot which he was using to.
Oh, that's right, but repeatedly he has given.
Yes, repeatedly.
2 to 4 times. One time,
external injury.
repeatedly.
Again, I am repeating for my let's do. 18/4/2024 ସମୟ 7 ଘଟିକା ହବ ମୁଁ ମୋ ଦୋକାନରେ ଥିଲି ତ ଅରୁଣ ରାଉତ ତାଙ୍କ ଦୋକାନ ଖୋଲିଥିଲେ ସେଇ ସମୟରେ ପ୍ରଦୀପ୍ତ ଶତପଥୀ ଅରୁଣ କୁମାର ରାଉତ ଦୋକାନ ସାମ୍ନାକୁ ଯାଇ ତାକୁ ଗାଳି କରି ଏକ ପିତ୍ତଳ ଢାଳରେ ପାଣି ନେଇ ସୂର୍ଯ୍ୟଙ୍କୁ ତାଙ୍କର ଅନିଷ୍ଟ କରିବା ପାଇଁ
First of all, he provoked.
No, my lord, it was, see, he said, my lord, other statement,
Read further, read further.
other statements clearly shows each day he was doing that because he was not returning money.
But what he said, author, just
My lord, so, ଏହା ଦେଖି ଅରୁଣ କୁମାର ରାଉତ କହିଲା କାଢିଦେଲା ମୁଁ କଣ ତୋର ଟଙ୍କା ନେଇଥିଲି ଶଳା ତୋର ଝିଅ ପଳେଇଛି ତୋର କିଛି ଇଜ୍ଜତ ନାହିଁ ତୁ କଣ ମୋର ଦିଶିଛ
yes, by the district. Yes.
ତୁ କଣ ମୋର ଦୋକାନରେ ତୁ ଆସି ମୋ ନାଁରେ ପାଣି ଢାଳୁଛୁ ଚଢାଉଛୁ ଏହା ସ୍ତ୍ରୀ ପ୍ରଦୀପ ଭକ୍ତ ରାଗି ଯାଇ ଧରିଥିବା ପିତ୍ତଳ ଢାଳରେ ଅରୁଣ କୁମାର ରାଉତର ପଛପଟ ବେକ ମୁଣ୍ଡକୁ 2-4 ପାହାର ବାଡିଦେଲା
2-4
ତାପରେ ଅରୁଣ କୁମାର ରାଉତ ଏକ ଲୁହା ରଡ୍ ଆଣିଲା ବିଶିଷ୍ଟ ପ୍ରଦୀପ ଶତପଥୀ ତା ଘରକୁ ଦୌଡ଼ି ଯାଇ ଏକ ଲୁହାର କାତି ଆଣିଲା ଏହା ଦେଖି ମୁଁ ଆଉ ବୁକୁ ପ୍ରଧାନ ଆମ ଗାଁର ବାସୁଦେବ ପ୍ରଧାନ ସେମାନଙ୍କୁ ଅଟକାଇଲେ ତାପରେ ସେମାନେ 2 ଜଣ ସୋଦାଗାରୀ ହୋଇ ଦୋକାନକୁ ପଳେଇଲେ ନିଜ ନିଜ ଦୋକାନକୁ ପଳେଇଲେ ଦୋକାନ ଖୋଲିଲେ ପ୍ରଦୀପ ଶତପଥୀ ଦୋକାନ ଖୋଲିଲା ଅରୁଣ ରାଉତ ଦୋକାନ ଖୋଲିଲା ଅରୁଣ ସାହୁ ସେତେବେଳେ ଦୋକାନ ଖୋଲି ସାରିଥିଲା ହଁ ତାପରେ ଦୋକାନରେ ବସି କାମ କଲେ କିଛି ସମୟ ପରେ instant ତାପରେ ସେ ଅରୁଣ କୁମାର ରାଉତର ଦେହ ଭଲ ନ ଲାଗିବାରୁ ସେ ତା ସ୍ତ୍ରୀକୁ ଫୋନ କଲା ଅରୁଣ ରାଉତ କାହାକୁ କିଛି ନ କହି ପୁରା କାଠ ହେଲା ବେଳେ ବସିଲା ତାପରେ କିଛି ସମୟ ପରେ ହସ୍ପିଟାଲ and my lord, when the person will say taking the name of the daughter, hey, definitely my lord,
Provocation was there.
provocation was from his end, from his end, and if my lord will see other statements, 151 statement, it will be seen that this promise of fellow, he was believing that that is the statement of other witnesses that each day he was doing so. Each day, yes, not that on that very day. Isn't it?
He died after how many days?
Same day.
He was taken to hospital.
After 7 days, but not that same thing like Indians well. Again, he returned to the house. The intention that again, I am not feeling well. When the intention was not there to do his life. He, as a government fellow, he believes that we should do the part of the time of पैसा में फिर कोई ता दुकान पैसा ना तो इतना खराब मंदिर चिंता करते हैं पर देखा नहीं मंदिर
He said also.
ସିଏ କହିଲେ ତ ଝିଅକୁ ଯୋଉ କଣ ଝିଅ ରଖିଲେ ତ କରୁଛୁ ସେ ଝିଅ କଥା କହିଲା ବେଳକୁ ରାଗିଗଲା ନହେଲେ ସେ ତ ଆଡୁ କରୁଥିଲା
Now since charge sheet has been filed, you repeat it. Petitioner is
I mean custody since April.
not
Here my application has also been filed charge sheet on 14/8/2024. 14/8 my application will be listed after 4 months.
within 15 days.
My lord, I'm 27/5/2023. My application was filed.
I am giving a direction to the trial court to decide the bail application within 15 days.
My lord, and after that it will be filed. It will be filed here, and it will be listed after again 3 or 4 months, my lord. Because one case my lord was supposed to reject, observing everything about the photographs. There my application was rejected immediately after my lord's direction. An application is pending since last 1.5 months here.
What to do? This is the what to do.
And people have in the case of intention, deliberation, preparation. Then, my lord, I'm quite concerned about the production.
Then list it after vacation, immediately after
My lord,
vacation.
yes.
Today I am not satisfied.
My lord, application. Then let it be.
Yes. 30. List after vacation, huh? 30.
Here the incident for lordship. Under section 420, he is in custody since 16/4/2024. 16/4/2024, he appeared before the police station pursuant to the notice under 41A.
And you are arrested.
Yes, your lordship.
Yes.
And so far the allegation against the petitioner is concerned, he was made
467, 468.
So Muslim लोक तो से अगस्त ऋषि କଥା ଜାଣି ନଥିଲେ ବୋଲି ଆଜି ଭୋଗୁଛନ୍ତି ମଧ୍ୟସ୍ଥତା କରିକି ଆଉ ଜଣଙ୍କ ଜାଗା କିଣିଲେ 2010 ମସିହାରେ।
Who is the informant?
Informant is the wife of the person who has purchased the property.
Impleaded.
Well, this is
what is the amount?
Amount as per her version that was 18 lakh. If you had the husband of the informant had given to the person who was executed the sale deed, and sale deed was also been executed.
He paid 30 lakh.
And that man is also accused with you.
That man, so wherever that man is not known.
You are the mediator. You are the mediator.
I am the mediator. I am a man of my lord.
What are the allegations?
63 years.
35.
Yes.
35.
Yes.
Where is that? 35.
35 agreement. Agreement dated. It is 27th December 2022. Annexure 4.
No, that is not there with me.
नहीं फाइल करा फाइल को ना इधर
That is not there with me.
ओपन करना अपन पार्टिसिपेशन ना
What do you want to show? It is not there here. Only 21. Page 21 I have.
Person they made the agreement on 27th December 2022. Petitioner with the informant that he will return his amount. What are you with that?
Agreement between this petitioner.
Yes.
Or the implead the informant. Mr. Mahapatra, let counsel for the petitioner seeks permission to implead the informant in the present case. The opposite party number 2. He may do so during the course of the day. Online. During the course of the day, issue notice to the newly impleaded opposite party number 2, returnable. They do whatever for. Implead.
Before 3rd October.
Before 3rd, immediately after 3rd, 7, 8, whatever. Because you have to implead and file the same requisite had to be filed thereafter the service.
7th October. My lord, for 4 to 8, I am not available. I will be outside.
Then what do you want? You tell me. 4 to 8 you are not.
9th.
Okay, 9th. Okay, 9th. But you filed the process fee today.
No, today itself I am doing.
Yes.
34.
Thank you, Lordship.
The decision case is not
Filed.
yes, madam. Being motivated by some cyber fraud matters to get a course through trading manner. The petitioner has deposited some amount before in different accounts, madam. And in the account of the present petitioner, he has deposited 3,82,000. This is the whole account. Since 60 lakhs amount from the informant has been transferred. Sunil Bera Nachiketa. Second is
Let the informant come.
Yes.
Let counsel for the petitioner seeks to implead the informant in the present case, the opposite party number 2. He may do so within 2 days and file on filing of the requisites. Issue notice to the newly impleaded opposite party number 2. Leave the matter also. Yes. 38.
Beg pardon, my lord. I'm through VC, your lordship. It's a below commercial quantity sees article 58 gram of brown sugar, my lord. The present petitioner is in judicial custody since 16th May 2024, my lord. And so for the instruction received, my lord, the final PR also submitted. It is a below commercial quantity of brown sugar.
So that is from the right side pocket of the petitioner.
Subject to verification.
One criminal antecedent is there, ma'am.
Subject to verification, he will go.
If antecedent part will come, my lord, they will reject the bail application.
58 grams of brown sugar, below commercial quantity, 65/2024, subject to verification. Granted. Yes.
My lord, previously, your lordship, I will take 30 seconds, ma'am. Previously, the police official booked me under the confession statement of co-accused, my lord. I am not.
You don't need bail?
Need bail, but verification of antecedent. If you, my lord, the verification antecedent part will there, then they will not grant me.
You have done your job. Be happy. Yes. Next.
39.
Discuss the petition is in custody since 10/5/2024.
10/5?
2024.
10/5/2024.
Okay. The case is
case diary is not there. The time, but 1 week time. CD 1 week time.
CD. CD. 1 week. After 1 week. Yes. Next.
The informant and the petitioners are major due to love affairs. The
petitioner keep physical relationship with the informant. Custody, मतलब 13/6/2024. The petition, initially the petitioner was after this honorable court in anticipatory bail. And this honorable court directed the petitioner to surrender. In pursuance of the order passed by this honorable court, the petitioner was surrendered before the learned court below on 13/6. In the meantime, charge sheet has been submitted. The case has been, the charge has been framed against the petitioner. He was taken into custody. I was what are the allegations? The petitioner went to the village of the informant to the one labor work.
Yes, yes.
1 minute.
Now, transcript matter submitted on 21/6/24 minutes. 21/6/24. On section 417, 372N, 371 minutes.
Yes.
And the 164 statement,
Read it.
here the victim stated that, ମତେ ବିବାହର ପ୍ରତିଶ୍ରୁତି ଦେଇ ମୋ ସହିତ ବହୁତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲା।
11/5/2024 my lords.
11/5.
My lords.
Recovery.
Recovery my lord, 2 accused persons my lord, and the present accused persons recovery was
121 gram.
My lord, the present December my lords.
In city is there, my lord. In city that is there. In city.
121, subject to verification, 120. I'm not seeing anything.
I'm fairly submitted my lords. And
I'm recording. If I record, I'll reject it.
my lord, sorry, my lords.
Better that let it be verified.
ଯଦି ଆକ୍ସିଡେଣ୍ଟ ଗୋଟେ ଆସିବ କିନ୍ତୁ ହବନି ଆଜ୍ଞା।
Already I have rejected it now.
ଆଉ କେବଳ
You have done your job.
ମୁଁ ଲେଖିଦିଏ ପାରା 6 ରେ 6.6 ଗ୍ରାମ ଗୋଟେ ଅଛି my lords.
Subject to verification. Yes. Next.
1 kilogram more than 1 gram accident my lords.
What do you want? Shall I reject it?
No my lords.
I have given you bail. You won't do what?
Accident of the
Once it comes, then we'll see. Yes. Next.
May I please your lords? There are two items, my lord. Second one is mild.
In this, there are two items.
First item, my lords. The first item, my learned friend is appealed.
Yes.
Now
yes.
for the second one.
Custody.
Custody since
That is 2 numbers of date of custody matters. So in my item, the actual person is custody since 24/6/2024.
24/6/24.
Yes.
Okay.
In the
the second item, in the second sub item, my lord, I am in custody since 13/10/2023.
10/23. Okay.
13/10/2023, my lord.
It's all right.
But the as per the
Same FIR, huh?
Same FIR.
not the same affair.
And the malice of fact is the case is there.
What is the recovery?
Nothing. Nothing.
Exclusive conscious possession, nothing.
Nothing.
After trying
The recovery I'm asking.
270 kilo of
270 ganja. 270 kilo.
70 kilo.
Yes. Conscious position. Whose conscious position?
My lord, here, my lord, that the final we are submitted on dated 21/23, 20B2I3. My lord, one CA, so far the petitioner Simia Gamango is concerned, he has got one criminal antecedent and that is similar in nature, my lord.
Yes.
And so far the petitioner
Gamango
item that Joseph Gamango is concerned, he has got no criminal antecedent, my lord. And apart from that, my lord, that I am reading that they are the, my lord, ganja trader, my lord, and they are the kingpin of the smuggling group, my lord. They both are, my lord. And one, I have read
recovery from whom?
My lord, I'm reading there. I'm coming, my lord. That point. That one Simia Gamango, my petitioner, and Joseph Gamango are dealing with clandestine business, narcotic trade, have stocked huge quantity of ganja at backward jungle, my lord. My lord. On seeing the police party, both ran away towards jungle by leaving the ganja bags at the spot. As per the instruction of the, my lord, instruction of the available PS staff, tried them, but they able to manage to escape from the spot and conceal themselves inside the dense jungle, my lord. Out of suspicion, we checked the packet bags and found 9 numbers of packets, jari bags were tagged at the spot. On verification, we found smell of ganja was coming out, and that is a minor contraband.
How you have apprehended? From where you have apprehended?
Minor that thereafter they are apprehended, my lord.
No, where from you have apprehended them? From in jungle or somewhere else?
After 5 months.
My lord, after 5.
Then
Date of arrest, my lord. My lord, that's
one is arrested on 13/10/2023, another is 24/6/2023.
24.
The FIR was registered. Where is the FIR?
22/5/2023. 22/5.
FIR is vice sponsors.
FR is page number
Vice
8,
sponsor.
my lords.
Yes, what are
They are
the?
the ganja cultivator, my lord.
They are
Both are ganja cultivator. And they are the traders and
The problem is conscious possession.
My lord, that are
Because see, you have arrested them, you have not arrested them from the spot. And you have arrested after 5 months.
my lord.
The recovery is made from the jungle.
Backward.
They fled away. Who has seen them? Who has identified them? Whether these two people or someone else? What is the evidence? Quality of evidence.
Evidence that is there in the that part of the jungle there sees the ganja and they are escaped from the spot.
Hey, who escaped from the spot and we see people there? Have anybody said that these are the two people those who have fled away?
No, my lord. That no such statement is there, my lord.
Nobody knows who has fled away from the people.
After 6.
Unless a sentence somewhere that these are the two people those who have been arrested and fled away from the spot. You show me anything?
No such statement is there, my lord.
Do you want to see it? Then they are entitled, sir.
So far the petitioner Simya Gamango is concerned. He is
Subject to verification.
My
Will not say anything. Subject to-
Minus one antecedent is in civil nature, that is totally a.
I will not say anything. Then I have to reject.
It is also.
I will reject your bill.
That
I am not here to see all this. Right on. Petitioner is.
Matters, one more clause. Here is the case where similar type of honor FIR is there, that one who.
Do you want me to decide the fate of that case? I will acute there and thereafter I will say that you are acquitted. What do you want? I will have
I know. But it is completely.
Better is to stop there.
Before the trial court, my.
Better is stop there. Better is stop there and take the bail and go. You see whatever.
But it is missing.
You do your job.
But it is missing.
Otherwise you are not entitled. See, recovery is 200, how much? 200?
170 kg. 270 kg.
270 kilo. Kg of ganja. Right. Both the let it be one word, one order. Both. Petitioners are accused in court. Allegation will be recovery up for the recovery of 270 kg of ganja is alleged in the proceeding. From the evidence collected by the police, which forms part of the charge sheet, it reveals that the petitioners were apprehended 5 months after the date of the incident.
One petitioner is 5 months and another is after 10 months.
The petitioner number one, huh? Petitioner in which case? Petitioner in
Simya Gamango is available 6 to 8, 9.
The accused petitioner, Simya Gamango, was apprehended after the 5 months of.
No, 10/4/2024. 10/4 after 11.
11 months.
Yes.
And whereas the other accused, what is his name?
Joseph
Gamango was apprehended after about
5 months.
After about 5 months. The allegation from the prosecution story is that these are the two accused persons, those who were there in the jungle, possessing the contraband. In the
Jerry, 9 numbers of Jerry.
When they saw the police, they fled away from the spot. The fact remains that these accused persons were not apprehended by the police from this spot.
Nothing has come on record to suggest that any of the witnesses have seen these two accused while running away from the spot. At least rather these two people, the two accused persons were arrested much after the registration of much after the apprehension and much after the seizure of the contract. Therefore, it can be safely inferred that there was the ganja, contraband ganja of 270 kg was not recovered from the conscious position of the insurgent petitioners. Regarding to the fact that the accused Joseph Gomang in BLAP number 6112 of 2024 is in custody since 24/6 to
13/10/2023.
13/10/2023, and the accused, what is his name? Where is that?
Simia.
Simia Gomango in, what is the number?
6289.
6112.
6289.
6289.
Yes, 6299.
89.
8999 is written here.
6289.
Me too. क्या क्या निकाल रहे हैं? 6289 निकालो ना.
6289, madam.
And then the other one?
6289 is with respect to Simia Gomango, and 6112 of 2024 is with respect to Joseph Gomango.
And the other accused so is in custody. Accused so in BLAP number so is in custody from 24/6/2024, whereas the FIR was registered. FIR was registered on
23 minors. 22/5/2023.
22/5/2022. 22 and it is not contraband seized is not in the conscious position of the petitioner. I am inclined to enlarge the petitioner some bail for the period and all. Yes.
Published.
43.
Published.
Yes. May I please, Lordship? Hearing this.
My lord,
Yes, the offense is under section.
to appear on behalf of the informant, my lord, I am filing the document.
Yes. The petitioners are in custody since 26/3/2024. 26/3/2024. Yes. For commission of offense under section 307, 325 and other allied offences. Charge sheet has already been submitted since 30/5/2024. And no criminal antecedents are there. Injuries are grievous in nature. Out of 3 petitioners, the petitioner number 2 is 7, huh? Yes, my lord.
Here also you have not filed charge, FIR, nothing.
But subsequently I have filed the FIR.
Where is that?
Fine. That might have there.
Okay.
Subsequently I filed the FIR.
What are the allegation against these people?
Petitioner that filed the victim returned from their crimes and all of a sudden.
Both the petitioner are assaulted to one Manu Sahu and Lokanath Sarmai by means
No,
of.
there are 3 petitioners.
Mittu Dharo, Pappu and Mukta. Mukta is the wife of the Mittu Dharo who was only present at the spot.
That there are, my lord, 10 numbers of eyewitnesses are there in this case, my lord. And all the eyewitnesses are supported to the prosecution case, my lord.
But all the
That weapon of offense has already been seized, and that extrajudicial confession is there, my lord. And that apart, my lord, charge submitted 27/5/2024, my lord. 27/5/24, my lord.
24. Okay.
Charge sheet submitted, my lord.
35/2024. 30/5/2024.
30/5?
Charge sheet?
पूरा अपन देखेंगे 30/5 दिन.
30/5. Charge sheet was submitted.
27/5.
27/5/2024.
I filed the copy of which, which is available.
Yes, I see.
That CCTV footage is there, and that entire incident has been recorded in CCTV footage manner.
The charge sheet for which offense you? 302.
Charge sheet has been 307, 323 and other allegations.
What? So,
Manner 314, 294, 323, 326, 307, 550, 35.
307.
307.
Show me the injury. Show me the injury.
Injury manner, that injury, I'm so far Monu Sangu, one of the injured is concerned, that he has sustained my lord. Two lacerated injury, my lord, and one multiple abrasion is there, my lord. And the lacerated injury are grievous in nature, my lord. Both the lacerated.
Which part of the body?
That is in part of the frontal to head, region of head, my lord.
Head.
My lord.
And
Both the
next,
lacerated head, in both portion, my lord, lacerated injury is there, my lord.
Monu and Monu and
Right side of
Monu Lokanath.
Monu Lokanath.
Lokanath.
Yes. She grievous.
No, the grievous one is not there.
Grievous injury.
Grievous injury. No, insofar as Manu, there is grievous.
Grievous. Both are grievous matches.
And
Lokanath also grievous.
Loknath,
Also grievous.
grievous.
Minor.
Both the
Weapon, axe.
Axe, madam. That has been seized, madam.
yes, my lord.
Yes.
It is admitted fact that, but due to civil dispute, my lord, on the date of occurrence,
Seven evidence is there.
the
That
informant,
makes your case what? There was intention.
yes, my lord, but so far as the allegation against Mitudhar is concerned, he has done all these things.
Stage of the trial?
My lord, as per my instruction, material witnesses have been examined and they have supported the case.
Then.
And this is the arising
When
arising of the civil dispute, my lord.
both the witnesses have already been examined.
Examined, my lord. Injured examined, both informants are examined.
Then you really appeal.
So far as I will say one thing, my lord. So far as the petitioner of the
These things are not there, you renew the bail, please. Petition is by 21.
petitioner number, he is a lady, my lord.
2024. Whereby his bail plea has been rejected. The charge sheet in the present case has already been filed on 27/5/2024. The Learned Counsel for the informant, an informant submits that insofar as the injured Monu and Loknath are concerned, their testimony has already been recorded by the court. Recorded by court. In view of the even the informant has already been examined. In view of the changing circumstances, petitioner seeks to renew the bail plea before the trial court. So such bail plea move, same shall be considered on the basis of material available. Yes, next.
May I say one thing, my lord? May I be permitted to withdraw the bail application on behalf of the petitioner number 1 and 2? And so far the petitioner number 3 is concerned, he is a lady, my lord.
The materials have already come on record.
Yes, so far as the petitioner number 3 is concerned, she did nothing, my lord. She was the only present.
Whatever, I don't know the evidences.
My lord, may kindly have
Do you have these evidences of these two people, Manu and Loknath?
No, my lord, 160.
So that will be there in the court, that the court has to see what are the evidence which has come on record by now.
But petitioner number 3 is the lady, my lord, and so far as two second is concerned, my lord, the lady may be favorably considered.
Yes, next.
My lord.
44.
My lord, petitioner is in custody since 2/4/2024. Initially, the FIR is registered under section
2/4/2024.
and FIR initially registered under section 341, 323, 376, 34. Thereafter, charge sheet was submitted on only 376 of IPC, my lord. And the age of the victim is 30 years and the age of the petitioner is 49 years.
49 years.
My lord, the case is improbable, but because of the allegation that
164 is there.
Yes, my lord, now I received this.
Although after lunch.
May I offer my sincere apology, my lords, for not being present in the first hour. I sent my associate and I was told that it doesn't come, but this has been filed before 30th of June.
I only expect that when a counsel says something, it should be fair enough.
Yes, yes.
And it was listed before some other court. You know that it is a connected matter. We took up that matter.
No.
Subsequently, I discovered the matter is listed today.
No,
That's all.
You should have told me that this matter is listed before some other bench. How can I pick up some?
It was never, it, after.
I saw, I have to release the proceeding. You told me this is a connected matter.
Connected matters.
You took up, I took up that matter. And subsequently, I heard you.
Yes.
Subsequently, that matter belongs to some other court.
No, my lord. What has happened? It is like this, my lord. I am fairly submitting. After this assignment was changed in 30th of June 2024 and later on, my lords, prior to this was before the court number 2. Whereas after the change,
Whatever what I did is I have not said anything.
well,
I simply said that it's the matter before appropriate bench. That's what I said. Nothing else.
this is appropriate bench, my lords. This is
I don't know. Let the Honorable Chief Justice decide it, which is the appropriate. If it is appropriate, it will come back to me. I'll just see. Because there is a proceeding and the coordinate bench is directed that the matter should be listed on 25th, today's date. And I, in between, I picked up the file. I heard it and I released the matter on 26th. When the registry called for the file to get it listed on 25th, I discovered that the matter is supposed to be listed on 25th.
no, my lords.
How can I pick up that file from some?
No, it is never, it is not done, my lords. This matter was listed.
Ideally, what you should have done is, if the matter is directed to be listed on 25th, if it is listed before that court, you should have said that connected matter is being heard. Please send it.
This was listed before my lord on 23rd.
Because on your mentioning, I picked up.
Yes. Now on 23rd.
I had no idea that this matter is being heard.
Absolutely, this is your lordship's domain. And on 23rd, if my lord remembers, your lordship gave 2 tasks. One to me, another.
I know, I know that.
Lordship wanted to know whether Priyanka Srivastava case is.
The affidavit was there or not.
Yes. Then second task was given to me about the tax deduction, that is 40 AIA.
So that was because I had no idea that matter is being heard by some other court.
No, my lord. This was being heard by my lord.
Wrongly.
No, not wrongly, my lord. From last week, because of the change of assignment, it was.
Anyway, nothing has happened now. I just asked the registry to list it before appropriate bench. If it eventually comes to me, then this is the appropriate bench. Let us see the registry to do it. I have not said anything.
My lord,
But it was
the mistake was because of my associate matters. He could not properly place the matter.
Maybe it was a bit disturbing, so therefore I just expressed it. Don't take it on my mind. I just forget in the morning itself.
It's all right.
I
beg apology, my lords, for this.
This happens. Yes, we should be little careful about it.
My lords.
Yes, thank you. That's okay.
Was filling that case notes that as per his calculation, the DA amount should have been less than 10%. I support the charge sheet note. This document produced by the prosecution with the trial court notes. My learned friends, the petitioner's counsel argued extensively. Yes, find an open submission, my lord. Your lordship record one line, my lord. I support the charge sheet. That's all. You have to close that hearing notes.
After vacation, after vacation.
2 p.m.
Because I can't write so many things now. And reserve then.
But
Two PM. Yes,
notes. This is correlation. I don't start today. Well, in this case, an order was passed on 23rd February 2024 notes. That order lordship can be carries at the time on the case economic notes. That order should not stay in the High Court for 1 day. That raises eyebrows. That particular order. Lordship, I will place that judgment note. That particular.
So which item?
Item 81.
81, 1 minute.
What my learned senior brother is saying, he will.
1 minute.
That my lord.
You have asked for adjournment, we are doing it, but just.
I agree with my lord.
81, no?
Item 81, the order dated 23rd February 2024 words.
Yes. Yes.
Only disposal of this case, my lord, this particular order to be merged, my lord.
Whatever my he.
ठीक है.
But this was passed by some.
That's right. It's passed by other bench, my lord, but there, my lord, the scope of appeal and scope of revision is absolutely, my lord, ended in a match, my lord.
It will be discussed.
My lord, I place that at the appropriate time, lords.
That is the yes, we are hearing the main matter.
Yes.
We will see. Okay.
Lord, fix a date, no? And he expected should be to I agree with you.
2 p.m. Yes.
On that day, my lords, on that day, my lords, lordship proves it.
Yes. May I please, my lord?
The petitioner has filed this case for quashing of proceeding.
Yes.
On the ground that on the self-same proceeding, dependent proceeding has been quashed and the criminal proceeding is liable to be quashed. And
what are the other group matter? Departmental proceeding quashed. So therefore, when was that those matters? Similar matter. The group. All the matters I am listing on one day. The same thing, the departmental proceeding has been generated. So on that basis, he is seeking quashing of this.
Dr. Meena Katan Panish case.
It up, you take the number form. Leave the matter along with.
Pardon. I filed the IA. If you adjourn one person shall be filed, that shall be adjourned.
Let us see if immediately it comes, then I'll deal with it. Yes.
Item 30.
30 now, 1-3.
Man, I mean, pardon. I that order.
We'll see. I'll pass the order. Let us see. 13, 1-3. Yes.
Item 13 subject to your lordship's kind consideration matter. There are certain materials. Today only I supplied the deposition copy.
Depositions, all the depositions are after January?
No, my lord. I want to understand that whether the complainant has been examined or not.
Only on August, madam. All these are the latest, madam.
So why don't you repeat your bail application?
Only on the next week at any date, madam.
No, what I'm trying to say is in January 24, the bail application was rejected. Subsequently, many materials have come on record. May be supporting prosecution, may not be supporting prosecution. You renew your bail plea before trial court. I will give direction within 15 days. Your bail application will be disposed of.
But actually,
that I do generally.
Well, I have just received all these materials, madam, all these deposition copies and along with the PM report and all these things. Only I pray that let the matter may be called. We commence in October 7, madam. I will definitely be on. I no further.
Case of 302. 302. So if evidences have come and the trial court, the court of first instance has to look into it while dealing with the bail. So I am giving a direction that within 15 days your bail plea will be decided on the basis of material which has come on record by now.
Only on 7th of October, madam. Okay.
7th October may not be possible. Give it after vacation. Give it after. But I'll do the same thing, I tell you. Rather, it is better that within 15 days I give a direction to the trial court to decide your bail within 15 days.
If you, I will be misunderstood by the
conference. Okay. Yes.
Item 50.
Yeah. After hearing cases, lordship directed from the deposition in the one line whether the lordship in the deposition matter in the paragraph 10 he stated as a case of consent matter stated I was escorted by the police to the court of magistrate at the time of recording my statement under section 164 of CRPC.
13, huh?
I have made my statement.
Okay. 1 minute. 15, huh? 1 minute. Yes.
I have made my statement being tortured by the police matter. 164 statement he recorded in paragraph 10 matter. Tortured by the police matter.
Being tortured by the
police matter.
Right. So
that is mentioned there, matter, but in chief says deposit other thing, but in para 10, what,
Para 10 up to the 164.
para 10 and cross examination, my lord.
What
164. That is usually I escorted by the police to the court to magistrate at the time of the recording of my statement 164 of this CRPC. I have made my statement 164 CRPC being tortured by the police, unfortunately.
It is before magistrate. What police will do?
But here is my lord. I am the scribe of the paper. I know the accused Lituna Rana who is standing in the court. Today the occurrence took place once. In order to attend the marriage function, I have gone to the house of the sister of my father in village Guali. There I developed talking term with the accused. One day the accused had called to me to come out of the house. While I refused to threaten, I refused. He threatened to me to die. I then came out from my house. The accused then brought me to the house of one Pappu Munda, located in the village of Chandala Sahi. The accused then married me at Shiva temple at Kitchen and applied vermilion on my forehead. But I subsequently came to know the accused was already married. We resided in the house for about 2 years.
Reading what? This is evidence.
This is the deposition of the victim.
You filed those things here. I'll consider those things. Because except to the rejection order, you have not filed anything.
Filed?
In the application, you have not filed anything, even not the FIR also. Bring something on record.
Yes.
Bring something on record. Land Council for the petition to file additional document to substantiate his case. Please the matter. Let him do so within a week. Please stop saying yes. Yes.
Well, the matter.
He will give it. Yes, next.
44.
The petitioner is in custody since 2/4/2024, my lord.
4/24,
my lord.
Yes.
My lord, the petitioner age is 59 and the victim age is 30, my lord. My lord, in the charge sheet has been submitted on where it has been mentioned that no evidence made out against the other accused persons. My lord, the fact of the case, my lord, on 23/2024 night, there was a melody program for which the victim and her brother with others.
Read 164 statements.
Well, and 2-3 grounds. One is that she himself stated that she has not remembered the date. And the FIR,
you are 44 years.
My lord,
your age is 44.
And she is 19. And she categorically stated in her statement that I cannot remember the date. And that apart, FIR, the incident occurred as in the FIR.
164.
And medical evidence is also says that there is no foreseeably sexual intercourse.
164.
ଗୁରୁ ପ୍ରଧାନ ମାନେ ଆମ ଘରକୁ ପଶି ମୋ ସହ ଖରାପ କାମ କରି
This aspect is also reflection from the evidences are already. Therefore, I am not going to enlarge the petition on the however, liberty granted to the petitioner to the after the victim prosecutory checks and examination. Yes.
That after examination of the
Yes.
Lordship will say the trial court will expect.
That's what I have. And it is expected that the trial court shall examine the victim prosecutor as a first witness, giving preference over all other witnesses. Yes.
What is the
Partition.
Yes.
IFR वाला extension of the
Extension of
time. The order passed 16/3/2022.
16/3/22.
I have not filed the order, my lord, but the coordinate bench, my lord, dispose of matter. And the case of 2011.
He was directed to appear. What?
They are not giving even if not supply the copy of the order. Yes. But the case of 307, my lord. But paragraph 2 has mentioned, my lord.
Yes.
This court directed if the petitioner surrenders and moves for bail before the court incision over the matter within 6 weeks hence.
Yes. 6 weeks. Granted when?
Granted by on
Which is the date? 16/3/22.
the order is not there, my lord, but
Yes, the order is there, 16,
3.
3/20/22. Right, and he is asking for extension for how much? How much time? The petitioner has moved the present application seeking modification of order dated 16/3/2022, whereby the coordinated bench of this court directed the petitioner to surrender within 6 months, 6 weeks.
6 months.
Surrender within 6 weeks. The petitioner surrender. And bail was granted, which?
My lord.
Bail was granted. Allow him to go on bail.
I have not given the order, my lord, but paragraph 2 has mentioned. My lord, one thing is there, my lord, provided no such graver offence except section 307 of IPC is pending against him.
We don't know.
We don't know. Nobody, my lord, moving the application.
Does he say in the application that there is no grave offence? Why he is not
only
suffering from fever and high blood pressure
for
4 years? That's the reason. Right now. Coordinate directed petitioner to surrender within 6 weeks and avail the remedy under law. The relevant part of the order is said under para 5 of that order. Para 5 of that. The petitioner has moved the present application seeking extension of time to surrender. The only ground in the application he has urged is agenda. Para 3 of the application. I'm not persuaded by the ground taken by the petitioner for seeking extension of the same, and so the application is rejected. Yes. None appeals for the petitioner. Yes.
48.
Right, please, your lordship. Lordship, may kindly turn to page 7.
7.
My lord, order dated 15/5/18.
Yes, cognizance of it. Yes.
My lord, next page will be the relevant portion.
Yes.
Cognizance said there is sufficient grounds to proceed under section so and so.
Yes.
This has been passed by the SDM Atward.
Yes.
In a complaint case. My lordship, may kindly turn to page 10.
10. Okay.
Complaint case.
Yes.
यहाँ जो भी अंदर अठवाड थाना another thing. यहाँ की पीएस केस नंबर 235 तारीख रेस्ट होगी कि वर्तमान सुधा कौन सी कार्य यार सुजोग नहीं आमर स्वामी आमको फोन करी सब कथा समाधान करने ब्रह्मपुर को डकाइले जहाँ फल आम सरल विश्वास कर आम साथी उपर वर्णित दुजन साक्षी को सांगे धरी 18/2/18 तारीख दिन ब्रह्मपुर ठारे पहुंचलु सेठारे पहुंचा पर मो स्वामी कमिटेड दी एक्शन इंटीरियर एक्शन
गले and Taki Mango.
The occurrence took place at Berhampur. Advil SDM has no authority to have no competency to take everything.
Whether it is continuing offense or
yes. ଆମମାନଙ୍କୁ ଏକ ନେଇ ଏକ ଅଲଗା ଗଲେ ଉପଯୁକ୍ତ ସାଙ୍ଗମାନଙ୍କୁ ବାହାରେ ରଖି ଆମକୁ ଘର ଭିତରକୁ ନେଲେ ସେଠାରେ ଆଗରୁ ପ୍ରସ୍ତୁତ ଥିବା ମୁଦାଲାମାନ 2 ନମ୍ବର ଏବଂ ଆମ ସାମ୍ନାକୁ ଜେଲ୍ ଜବରଦସ୍ତ ଉଲ୍ଲଂଘନ କରି ୱେଷ୍ଟ କରିବାକୁ ଚେଷ୍ଟା କଲେ ଆମକୁ ତଳେ ପକାଇ ଦୁର୍ଗା ନାୟକ ଅସଭ୍ୟ ପ୍ରଭାବ ଦେଖାଇଲେ ଏବଂ ଆମ ସାମ୍ନା ଆମକୁ ଜେଲ୍ କରି ଉଲ୍ଲଂଘନ କରିବାକୁ ଚେଷ୍ଟା କରିଥାନ୍ତି ଆମକୁ ଚିତ୍କାର କରି ନ୍ୟାୟ ମାଗିବାରୁ ସେମାନେ ମିଳିତ ଭାବରେ ଆମକୁ ପିଟି ପକାଇଲେ the occurrence took place at Berhampur. So the LTO Advil has no competency to take cognizance.
Yes, who is appealing?
No, notice has to go. Complaint.
Because the entire incident had happened in Berhampur. And the last 2 lines he says, ଆମକୁ ଜୀବନରେ ମାରିଦେବାକୁ ଧମକ ଦେଲେ ଅଣ୍ଡର ସେଠାରୁ ଫେରି ଆମେ ଆଠଗଡ଼ ଥାନାରେ ଲିଖିତ ଏତଲା ଦେଲୁ କିନ୍ତୁ ସେମାନେ ସାହାଯ୍ୟ କରିବା ପରିବର୍ତ୍ତେ ବିଭିନ୍ନ କଥା କହି ଆମମାନଙ୍କୁ ଥାନାରୁ ତଡ଼ିଦେଲେ। Incident happened in Barampur. The complaint was given there in Athod Thana.
Notice
Since it was, they did not accept.
notice complaint case.
Right. Issue notice to opposite party number 2. Written notice also.
Complaint case.
Oh, complaint case. Opposite party, sole opposite party. The perusal of the complaint annexed to the petition reveals that the entire incident as complained of, entire incident on the basis of which the complaint has been filed appears to have happened at Barampur. After the incident happened at Barampur, the complainant complainants alleged that they came and gave an FIR, gave a complaint case before the Athoda police station. The Athoda police station did not pay any heed to the complaint. Therefore, they filed the complaint case. The consequently, the petitioner submits that despite the fact that the entire incident alleged to have happened at Barampur, the Athoda SDGM has taken cognizance of the offences on the complaint filed by the opposite party number 2. Issue notice to the opposite party number 2, written over so and so. In the meantime, proceeding before so and so is stayed. Yes. What happened? There is a bereavement in the family of the counsel for the petitioner, and the adjournment is sought accordingly. Yes, 50, yes.
May it also for the petitioner play that a matter be taken up on some other date.
Why interim order is there?
No, Your Worship, nothing.
Adjourn on request. All these things will go in December, huh?
Okay.
Yes.
I am for the opposite party. Lordship, I am for the opposite party in 49, Your Lordship.
Yes, adjourn. Yes.
Yes, Lordship. For the opposite party.
Last occasion, my lord was pleased to adjourn the case.
I have instruction to appear for
Opposite party number 2.
Instruction to appear for party number 2, will you kindly adjourn?
Notice return. Written. Persons to the receipt of notice, the opposite party number 2 has entered appearance through Mr. Divedi. He wants to file Bokalatnama on behalf of opposite party number 2 and file objection. Please the matter on say interim order. Interim order, past area, sir, continue.
Interim order dated 8/2/2024.
8/2/24, sir, continue. Yes.
The extension and date of surrender matter, order dated 14/5/24 matter. Extension of date of surrender matter, order dated 14/5/24 matter. Due to illness of function advocate matter, lower court on or before 36/24.
What do you want?
Extension.
Extension. Extension till? Or the for the reasons stated in the application number 2515. 2515. The time for extension is time for extension to time for surrender is extended till 20th of October till 20th of October. On or before 20th of October. 14/5/2024 is the order. Yes.
All other remain.
All other conditions remain same. Yes.
Before.
May I please, my lord? My lord, this is an application from action of the police. My lord, may I have a glance to the annexure A, my lord. My lord, my order dated by annexure A at page 9, my lord. IO.
Now, what do you want?
My lord, my lord, what happened in this case? My lord directed the IIC Chandrasekharpur, Bhubaneswar, to execute the NBW which was issued since November 2021. My lord, that order was passed on 23 May 2024. And the order, my lord also directed to survey a copy of this order.
It's not there.
No, not yet arrested. My lord, I have also intimated the DCP.
I have to take instruction, my lord.
See, there is a direction.
It's I, my lord, this file.
But there was a direction that you execute the NBW.
Yes, my lord, your lordship has been passed the order on 23/05/2020.
My lord, on that day directed that the NBW should be executed within 10 days. But that unfortunately that 10 days has not been there. But however, it has been directed to serve a copy of the order.
By the order dated 23/5/2024, IIC Chandrasekharpur police station was directed to execute the NBW issued on 22/12/2021 by the court of JMFC bracket C Cuttack in ICC case number 102 of 2019. 29. However, the IIC has not complied the said order, hence the present application. Issue notice to the IIT, returnable within returnable immediately. Explaining as to why the order of this court passed on 23/5/2024 has not been complied as yet.
Next week also another.
54, 55, 56.
54, 55.
54, 55. Ask for explanation. Yes.
56.
May I please, your lordship?
Yes.
And on other occasion, your lordship has issued notice to open number 2. This is a case for crossing of the. Yes.
Service complete.
My lord, last time, my lord, 3 copy.
Free copy.
But I have
Yes.
and I am having also an affidavit, joint affidavit.
We'll find the affidavit, right? Pursuant to the order dated 3/9/2024, the so-and-so enters appearance on the opposite party number 2 and wants to file an affidavit of objection. Affidavit of objection. Joint affidavit.
Yes.
I'm sorry, my lord.
It's again, the issue.
Settled, my lord.
The parties are there.
The parties are not there, your lordship fix another date.
Settled. And he states that the parties have settled that dispute at the next date appearing, the party will be present in court. These the matters when 21.
Next week,
Next. Fourth. Yes.
57.
Yes, sir.
P7 I have received the files. So transfer from one to another, one to another. Lastly, I have been handed over these files. The counter is the file. And the HCR is available before your loss. So
what is your submission? Everything is there, read and pass the order.
no, the counter, the copy of counter.
as somebody, some great people have said that the best job in the world is the judge of a high court, provided he does not have to write any judgments. That's like the most onerous responsibility.
Yeah, absolutely correct.
Ready? May I pray that I have not the counter with me, which I will find on our view. Because the copy of our counter is not available with me.
Your counter to be served by the court to you.
I pray that
if I'm there, I'll give a copy. I'll check.
Then you tell that
I'll tell my associate to give
when will you be ready at least?
Let's call it after vacation.
You give it so that you give, sir.
Yes, sir. After vacation, you'll also make it on 23rd. If it's 23rd or 24th?
23rd?
24th?
24th at 3 o'clock.
Grateful.
Don't ask for adjournment. Let us finish it up.
Yes, yes.
3 matters are there.
Yes.
Senior is for one and other Devashish Panda is
I will try to make it very short because.
So 24th at 3 o'clock.
Yes.
24.
24th at 3 o'clock. Please give, your instructing counter. Copy of the counter he will give the counter.
I have to wait for copy of the counter.
No, he doesn't have to copy, he will take it from him and you.
No, what I have that counter may be different because he's a separate case. So
Okay.
his counter I don't.
His counter is.
I don't. He may office may be having.
Wait, wait, wait,
No, the office may be having.
Probably there is nothing to find counter in my.
Maybe, I don't know.
Walk over and.
Grateful, sir.
The parties to.
I don't know.
And then I'll just, the parties to exchange the pleading amongst them. Okay. Leave the matter on
23rd
High Court at 3 o'clock. It's made clear that no further adjournment shall be
Yes, sir.
And my prayer is that this DA and DK Mahapatra, SC Vigilance may be deleted because he was in 2001. So my name may kindly be reflected.
Are you sure
that you will be there after
I do not know my name may be there after. If I will not be there, new council will come. 56, 59.
Yes. What is this matter? Mr. Nanda?
Yes, but in this case, we have already filed the notes. The lordships can, pleadings are complete also, notes we have filed along with the judgments.
Yes.
The lordships can just take up the note.
State also filed a written note.
State was, I think they have also.
They have also filed. Yes, you are ready.
Well, listen. Chutti पर है ऐसा.
Okay. Please sit immediately after the taken. Follow, you date the hearing it. Subject to seat convenience. Either an entry want to continue. Entry want to continue. I have heard it. 57. in matter of
57.
I know.
NCR has already been received this court.
60.
Indirect state.
Yes.
29.
When NCR is here, we'll have to cannot do.
Indirect state. Yes.
Item 60.
In this case, my lordship may create to call it some other time after the.
What is this? Let us understand. What is this matter?
Seriously?
Let it survive.
Yes, yes.
2008 matter.
Yes, it survives, my lord. It survives.
Last time this notice was issued, the building of long back. So I filed my record for the opposite party to the informant here. There was a
The entry order in 2019 and 9.
Yes, my lord.
The matter. This is challenge to what?
there was a loan fraud. Consumer was the officer of the bank.
What did we challenge? Cognizance order.
Not me. I am for
Cognizance order. And the state on 9.
2015, the matter was. Matters, again, there was a restoration. It was again restored. Yes.
Do you have a case?
Well, we do have a case, my lords. We do have a case, my lords. If not, I would have not made a submission, my lords. We do have a case, my lords. A small bond for lordship can.
Matters are pending for years.
The opening as well, 24 years, my lords. Learned senior will appear in this matter, my lords.
Okay, right on. Now, this present matter is pending since 2008. 2008. Entry order 2009.
9 minutes.
9 to 2009. That order.
9 to 2009 minutes.
On 9 to 2009, there is an entry order saying the proceeding before the court below. That the same entry order is continuing till date. The present matter, in the present matter, petitioner have assailed the cognizance order dated. Cognizance, the order dated 5/1/2007, whereby cognizance for offence under section 420, 468, 471 of 418 and 120 BIPC has been taken by the court of HD James, Bhubaneswar. Mr. Patnaik and counsel for the petitioner seeks an adjournment. Leaves the matter from disposal immediately vacating for review. It is made clear that no further adjournment shall be granted in this matter. In the event the petitioner seeks adjournment on the next date appearing, the interim order operating since 2009 shall stand it shall be vacated.
May I only pray 24 तारीख को if the date can be fixed.
You take the date, but if you ask for adjournment, the interim order will be vacated. Challenging cognizance order in 2007.
Well, allegation is that here
Interim order taken in 2009. And is operating. What is this? It's a case of 424.
I know.
What is the amount involved?
4 lakh है.
Only. Why would you give now? You have enjoyed.
We were only the sanction authority. But
Shall I send the matter to mediation? Will you pay something and finish? I'll pass the cognizance order and finish that.
So, Mr. Assume that
I'll send it right now. It is matter of 4 lakh rupees. Why are you wasting time? About a decade? More than a decade?
As to officers had decided.
Think over.
Will think over. Yes, no. Yes,
they will also be happy if you pay a little bit, lesser than 4 lakh rupees. Actually, they will be happy to get. And I'll finish it up.
Right now.
I'll call the cognizance order. Come with some.
Yeah, we'll do that.
It is bank. Complainant is bank.
Yes,
yes,
yes.
Malan Singh is appearing at she's appearing for the first.
Why not you settle bank?
He was our officer.
That's why you have to.
Yes,
settle.
no problem. You can approach it.
Settle. Yes. Come with some proposal.
We'll try that.
You also come with some proposal. Use your staff, and if you can reduce little bit money, and I'll persuade them and pay it, and I'll pass the cognizance order. Finish. Okay. And please come with that.
Interim interim order to continue.
That's that. That's the whole gamut is that. The interim order to continue.
Yes.
61. Come with a reasonable offer. And I'll persuade them. You pay the amount, and if you want some installment also, I'll fix an installment.
The whole difficult was that I had taken prior approval of my superiors, and the approval was given by the fact-finding authority. This is on which I had sanctioned. They did everything. Approval was given by the same. I only sanctioned based on both of the reports.
What happened to the other accused persons? They are facing trial.
Yes, they are facing trial.
They are facing trial.
They both are non-banking clause. I'm
facing trial, or because of the stay they are also.
They are facing trial because of us, because we are the only bank officers. Others are not non-banking officers.
The trial is split.
I think so. That will take.
What the position?
That will also take instruction.
Coming up the same.
You also seek instruction.
We were in the middle. They did it. We had to only.
Okay.
Those were the borrowers and you were the officer.
Yes.
Only way to do it because I had approval, so I had to.
You get full instruction.
61.
Yes. 61. This is also like that. Huh? Interim order operating from 2000. When the interim order was
Actually, my lord, I will take a copy from the court because there is no file is available in our.
So just I am looking at the interim order. When the interim order was passed, admission, either in interim or these are the matters where the proceedings were written by the honorable judges handwriting. Those are the days. Suspending.
GST margin. Entry model is there or not? Yes. None APS for the petitioner. Consequently, for the state submits that he doesn't have the copy of the petition.
Petitioner was on BC, but he was not audible.
Okay, in the interest of justice, Jana, next week. Yes.
62.
62 minute can be taken up next week because I have heard that petitioner has been died. He is the sole accused.
Sorry, I'm sorry.
Petitioner has been died by the lower court advocate. I will let you make sure that it is confirmed.
Okay, entry model was continuing.
Yes, madam.
See, this entry model is operating since again the same thing. The petitioner has died.
That I informed the lower court advocate. I did sure from the petitioner's family.
The counsel for the petitioner seeks an adjournment to ascertain the well-being and the status of the present the petitioner. Petitioner, please the matter next week.
63.
I'm in BC, my lord.
Yes.
My audible, my lord.
Yes, yes.
My lord, connected CLMC 1771 of 2011. Connected, my lord. Let it come next week or after vacation. And in the meantime, my lord, more than 10 petitioners died, my lord. 2011 matter. So it has to be secret so that.
Okay. Leave the matter along with
1771 by 2011.
2011.
My lord.
Next week. So yes.
Yes,
Yes.
65.
64 charge है
64.
65.
May please.
Yes, sir.
Here, petition for my lord is the complainant, and you have challenged the order passed by the land magistrate, directing him to file a sanction, to obtain sanction to prosecute against the opposite parties. My lord.
Yes.
My lord, we see the order.
Who is appearing? A notice was issued to opposite. You have not included the informant. Is this a complaint case?
My lord, I have filed reports in the year 2018, 31/8/2018.
What is the status?
With signature of someone else than
One opposite party has filed counter.
Opposite party. There are 8 opposite parties.
One opposite party has filed counter, opposite party number 8. Basanta Sahani, who was the author?
8 opposite parties.
My lord.
This matter is also pending since 2018.
My lord. I am ready to argue. Whether the short question comes up here.
Now let us see what is the position of opposite party, because arising out of a complaint case. Because final form was filed thereafter filed test petition. Cognizance is taken.
My lord. My lord, can obtain their whereabouts because they were the government officials. Accordingly, they have been taken as an accused. They must have been transferred. For that reason, the requisites.
All of them are government employees.
One was SCF. The then SCF of Civil Park Tiger Project. The second one is by that forest range officer.
Now filed anything.
I will try to solve a copy through police if the address is correct, because
address correct. One अगर forest range officer SCF not option है. रिटायर क्यों दीजिए कहीं रेंज ऑफिसर तक है रिटायर हो.
Then the IIT of which police station?
मतलब धामनगर. Dhamnagar.
The despite issuance of notice, the private respondent could not be effective for various reasons. The IIC Dhamnagar
police station is directed to serve the opposite parties number 2 to 8 and submit a report before the court. The extra copies of the petition shall be supplied to the state council of the state by the petitioner during the course of the day. At least give that extra copy, 8 extra copies. Entry model to continue, please. After extra copies, please give.
What the expert was raising? Let
Let him give a report, IAC. See.
Well, let us start with the extra copy. Because that police station is different.
Yes, sir. Yes.
I am for the opposite partner 2 mile or wife.
Yes.
My lord, I am the petitioner. In this case, the present petitioner in the opposite party before the learned trial court.
Are you ready?
Yes, ma'am.
The present petitioner in the opposite party before the learned trial court.
1 minute.
Criminal proceeding number.
1 minute. Sir, you have a matter?
3 p.m. brother.
3 p.m. Yes. Yes.
The present petitioner in the opposite party in the learned trial court in criminal proceeding number 255 2017 against whom the learned trial court passed an order directing the opposite petitioner to pay the maintenance money monthly to the opposite party.
How much?
10,000. The order passed by the learned trial court is obviously shows that it is a legal error. The learned trial court has committed a legal error and suffering from legal infirmity. As because even if it is observed by the learned trial court, my lord, kindly come to page 16 of the TLMC petition.
Yes.
16.
Yes.
It is 16 last part. Admittedly, a joint petition was filed by it is observed by the learned trial court. Admittedly, a joint petition.
Page 16.
Page 16.
It is evidence. It is evidence of.
It is the it is the evidence of OPA W1 that the parents of the KW1 concealed one fact that the petitioner is of relevant person, my lord. Last 5 lines.
Admittedly, the parents of the.
Admittedly, a joint petition was filed by both the parties under section 13B of Hindu Marriage Act 1955 before the senior civil judge Gunapur by mad case number 77 2014, and the said case was dropped due to non-prosecution as the present petition wife did not appear before the said court to adduce evidence. It is apparent on the face of the record that both the petitioner and the opposite party both have filed a petition taking.
I understand it. Go ahead.
They are living separately by mutual consent. They are living separately by mutual consent.
When the order is passed in the 125 CRPC, and he challenge this order, my lord.
Let him continue. He's saying something. Because you are inferring that because the 13B petition was dropped. Therefore.
No, my lord. It is apparent on the face of the record.
Why? How? 13B was filed.
No, my lord. No, my lord.
And first of all, there is no question of evidence in a 13B petition.
My lord.
You only consent.
My lord.
First motion, second motion.
Kindly come to page 30. Kindly come to page 30.
Yes. Yes.
Both the parties have filed the petition that they are living separately by mutual consent. Page number 32. F.
Merely saying separately mutual consent doesn't mean that the decree will follow.
No, my lord.
You have to have first motion, second motion. He has to give the consent for dissolution of marriage.
It proves that they have living separately by mutual consent. And law.
I understood. Then
my lord, 125, section 125.
Is it your case that you are trying to say that since she has withdrawn
from your company voluntarily, she is not entitled. That's what you want to say?
Law said that.
Why? That you want to say what?
Pardon me?
Is that your case? That she has withdrawn from your company by her own will, so therefore she is not entitled to maintenance. That's what you want to say.
It is statutory provision of law, and also the pattern of judgment says that if the wife is living separately by mutual consent, she is not entitled to for maintenance.
Where is that?
From the husband.
Where is that mutual consent? So the provision. It says that if the wife withdraw the company of the husband voluntarily, then she is not entitled. That's the law.
Yes,
You are interpreting the law very.
No. I am not interpreting. It is decided in the case of people.
By the way, what are you doing? Come to the point. What are you doing for living? What is he doing for living? What is he doing for living?
My lord, just submitting the question of the
point.
He is not paid a single price since 2020.
What are you doing? You are for living.
No, my lord.
To the contractor, my lord.
No, my lord.
To the contractor, and you would capable of paying the maintenance body.
As per judgment of the
And my lord,
Rajesh versus Neha, the parties to file the affidavit. Leave the matter directly. File both of you file affidavit.
and there was to be one submission, my lord, because due to the tendency of this CLNC, now the execution proceeding filed with the contracting, my lord. So most of my lord, case. I find, my lord, that the present case is not coming under that category. If my lord will see paragraph 25, 26 and 27.
Last
Order matter.
very
Moderated 12-9 orders.
12-9.
No affidavit, as the first words the case.
That is not necessary because two types of things are there, madam. Well, a law postulates if the complainant will pay for an investigation under 156(3) or subsection 3 of section 156, then he or she is to file an affidavit in support of the contention of the fact that she has lost the or he has lost the information before the police. Police has.
I want to say that if it is complaint under 153, Priyanka Srivastava is required. If it is a section
And
200 complaint.
and also,
that's what
yes, this Hon'Ble Court, our Hon'Ble Court has also taken note of this
In one
fact that reported in 2018.
I take that.
2018 value 70 But here,
It's a 200 petition, complaint, so Priyanka Srivastava doesn't apply.
yes, yes.
I take it.
Yes, correct.
That should be because the inquiry follows under 202. So affidavit is not required. In any case, that
Yes,
complaint
yes,
has to
yes,
be,
yes.
tested.
Malak.
Here 156.3 inquiry is not required. So therefore affidavit is required. That's the simple fund.
The simple fund.
Why to level on that?
Right.
Yes.
Malak. Here the case is, initially a fair was lodged against the present petitioners,
Yes.
those who were working under the complainant.
You are challenging the cognizance order. So the complaint and 200 statement.
Yes,
Case is
the case was ended in final report. Initially it was a fair, and after a thorough investigation of the case,
Where is the complaint?
let me kindly see the complaint petition.
Your name is Vishwanath Jana and Ajay Rao.
Ballot.
Okay. Come to the complaint. Come to the complaint.
That is ballot page 25.
Yes. Vishwanath Jana. The accused persons misbehaved. The complaint will be I know that it is more than the information showing it's not in court point. And they should be used on
Departmental interest dispute and which has been given a dollar of criminality mallet.
What are the cognizance taken in this?
Offense under section
3?
I'm for the petition.
323.
But that is page 44.
323, 342.
241 to 94, 506 by 34.
What is this allegation?
That's admittedly what my learned senior stated. It's an interdepartmental.
So why don't you check what is this?
Yes, sir.
It's what
is valid personally
nothing.
They were nominated.
Wasting crucial time for bloody.
They were nominated during departmental proceedings. They were terminated from their job, and thereafter they went in appeal.
Shall I send for mediation, settle it or quasi?
Lordship services, lordships are directed for mediation. Lord,
Going in and send it mediation. Okay. Send it for mediation. The petitioner is agreed by the order dated 12/4/2022 or passed by 3 p.m. Bhadrap in IPC case number 133 of 209. Whereby the cognizance for offence under section 222 the parental initially the FIR was registered on 15/5/2018. After investigation, the police filed a closure report. Agreed by the closure report, the complainant, opposite party number 2, filed a complaint case. Being one CC case number 133 up to 109. The allegation in the complaint case reads as under page 20, one paragraph. Subsequent thereto, the statement of the witnesses pre-summoning evidence of the witnesses were recorded, and the trial court has taken cognizance on the basis of the same. Regarding here to the nature of allegation, which are very minor elements. I think we settle appropriate to relegate the parties to the mediation center, the High Court mediation center, for exploring a possibility of settlement. Both the counsel appearing for the parties that was given consent to the same. Let the matter be referred to mediation center. The mediation center, the parties to appear before the mediation center on On 6th, on 9th, huh? 9th. On 9th of this month.
9th of October.
9th of October.
My learned friend says well after that.
It will be after vacation, Lord, sir.
9th October you appear and seek an adjournment. So it will be, you know, one sitting may not be sufficient. So then,
if my learned friend will take initiative, it can be done.
everything is in
Nice.
these ones are in ठीक है proceeding stage. Yes. Checking the dispute is very, very minor.
Please, trivial. Connected है हमारे ये तो दूर नहीं चल रहे.
The connected matter,
It was
the connected matter, the present complainant and his superior authority were again in another complaint under section 200 and thereafter 202 inquiry, they are cited as an accused in 354 case, but a separate set of complainants.
No, this is not
Clarify. We'll see if that is worked out, then we'll.
This will be worked out also.
That can also, if lordships may be pleased to send that also for mediation.
But who is appearing in the second matter?
Was appearing, Mr. Mahant was appearing, not my learned senior.
Minor, it was adjourned to 24/10.
It was adjourned to
That day we'll see. That day. Yes. 3 o'clock matter.
Lordship, it was defined during the earlier occasion, but due to inadvertence, it has been tagged.
Adjourn we'll see that. How many matters in them? And thereafter?
Item 75, Your Lordship. It was fixed up at 3 p.m. today.
I'll take, sir, I'll take 68 because there is a personal appearance. Thereafter I'll take your matter. Yes. 68.
Well, I go to the last order matter. Both the informant and the accused person are present before which court, my lord. And the matter has been amicably settled between themselves, my lord.
Yes. What are the offences?
Offences, my lord, 341, 294, 363, 34 and section 6 of the Postal Act.
Yes.
Which is arising out of the complaint case, my lord.
Mr. Ravara, just see. Which matter?
Complaint case. Arising out of complaint case. That is complaint case number 51 of 2019.
What complaint case it is? POXO?
POSCO, yes, section 6 of the Postal Act is also there, my lord.
And how is it?
Pregnancy, my lord, both are married, making and swinging both, my lord.
But how is it a complaint case? It is state case?
That is, my lord.
It is state case.
That is, my lord, 19/8/2019, my lord. What is
the age of this boy?
By the time the boy was younger, my lord. But the girl was minor.
25. Girl? What is the age of the girl?
22 years old, my lord.
Girl.
My lord. And goes to the child.
Yes. They married.
Oh, yes, more than my lord.
Yes.
They are present also before the court.
Chandan Kumar Das?
Atota.
Yes. Ramesh? Chandramana? Yes. What about this? Ramesh Chandramana. Where is the girl?
The girl, my lord, lordship is last time last time because she was present, the lordship directed don't come with the child. Yes, yes, the last time the lordship was directed only to the petitioner and informant. The value also there. But as because the lordship did not
The victim girl. Party number 3 to the petition. The purpose of the parties the this is a oral statement of a council. I do it and
one short argument.
Next week. Next week.
When there can fix some matters because
But you file affidavit. File affidavit. File the marriage certificate.
Marriage certificate.
And birth certificate of the child. Where the name of the father is written.
Yes, yes.
And mother name is also written.
Yes, yes, madam.
All these things placed on record. Placed on record. Then we'll see. Okay. No, they will have to come. They will have to come.
Item 69, madam.
All these matters, they fixed. I have fixed one matter for 3 o'clock. All these matters will be spillable to tomorrow. Remaining matters.
Tomorrow.
It may be someday.
Next week? Sixty-nine, he has a problem. I am sorry. Next week.
I then to the opposite party.
All rest of the matter will be delivered tomorrow.
Item 78 minutes.
69.
69 the CRLM 7 5 3 of 22 he might be moved down.
Maybe
Move that along with that.
Item 78 pending approval. Tomorrow.
72.
That's item.
Let it come tomorrow and see whether interim orders are there or not. I will not. Interim order is there. And for the petition. 72 million.
Item number 76.
Let me see here at 3 o'clock matter thereafter.
Item 75 fixed for
75.
Item 75, your lordship.
76 my lords.
Let it be there.
Item number 76. Tomorrow day after will be typical lordship, we'll call it 76 again. State is there, my lords. Interim order should continue, my lord.
The hearing matter which your lordship wants to take up this matter. I have sought for certain documents. Like this.
Which one? Where Mr.
Senior for section order and three other documents from it has not been supplied to go through and prepare the written note. And I have prepared a short written note drafted. But to look after the documents which I relied on that sanction order. Mainly my senior.
The argument he has indicated and brought something, my lord. I'll address my lord on that and then my lord can I'll give all the judgments to my lord so that it will.
Sanction order, my non-respected senior stressing upon the sanction order. So that copy is not available with me. The sanction.
The prosecution does that copy of lord. What is this?
He is proposing is he'll argue his part and you can address later on. Huh?
Let my lord respect his senior.
Can be court.
No, case cannot be available because all the entire
Get the case diary. I'll look into it.
No, case diary cannot be available because the case diary is probably without the learned.
No, what he's trying to say is the earlier IO has categorically mentioned in the case diary that the case is to withdraw.
Yes.
Despite that, the subsequent IO has proceeded and got the sanction.
My lord, there are three IOs. Three IOs have investigated into the matter. The matter which was investigated by the last but one IO, he indicated to some extent he got some information. Thereafter, he himself investigated into the matter. And he, after most part of the investigation, he concluded he just handed over the charge to 2016 who filed the charge sheet. So the very same IO who had actually my respected senior that we found from the case that certain deviation was there, the less who was there. So after he himself took up the investigation again after the direction of the SP. So that is the point. That means in the direction of the SP, he enhanced it. That is admitting.
You get the case diary also, let us see.
Because it will be all the complaints are submitted before the lower court.
Having a duplicate copy, yes.
No, I will ask.
He's asked if you have that, then we thought of that issue. That's the main issue you had.
Yes. No, you have to address whether your lordship is to decide whether charge has been framed. According to the framing of charge, case has been decided or not. Case diary internally mentioning by the IO then cannot be considered.
Then you argue. Let me
Yes.
This is the argument, my lord. I will see, I will whatever. Yes, material happen. But before my lord, that item, which was that item, my lord, 80? Let him conclude, you argue. Yes, put the losses, time permission. Yes, the rest of the board is discharged. The losses, only item 72 may kindly be kept on 8th of October. 72 tomorrow, I'll take it if you are there and with your losses, I may not to. Okay, not after, 8th of October. Who is the mentioning? You are appearing for one, petitioner. And who is it mentioned there? That's the whole problem in the, somebody comes and mentions and takes it. Then without taking. Then it's all right. No, say 8, if you want 8, then keep it, but keep it on 8. Entry order to continue. Entry order to continue, 72, item 6. That is just see the cross ID. Yes, Rajasri Khattu. Okay. Your name is also not there. Sanjeev Monty. And who mentioned that? No, the other side. I don't know the other side. 72 not that. 75, not 72. 72 mentioned. I'm not mentioned. Anybody can come and mention anything and I'm sitting here throughout. Sorry to interrupt. I found number 79 maybe tomorrow. Yes, tomorrow. Tomorrow only. Automatically take it. Yeah.
Item 75, Your Lordship. I am seeking for an adjournment, Your Lordship. Senior advocate is not well, Your Lordship.
Yes.
Last order to continue, Your Lordship. Last order to continue, Your Lordship.
Yes. Well, let me kindly take just 82. Well, in the line of Ashok Agarwal's case of the Supreme Court, mandate was given to the authorities how to give the sanction. Well, I passed on that. I've given you. The problem is if you hear in the piecemeal, that is what is happening. Very problematic. I'm only saying that I'll complete sanction today. I'll complete sanction today, which I think I can. And thereafter, my lord, I'll go personally to what my case is, my lord. And my lord, I have a detailed note, I can file it. Yes, I can file it. But let me kindly see this. You are showing me the judgments now. No, my lord. This is a mandate by the state of Orissa to the sanctioning authorities. How we should be doing it, my lord, on the basis of the CBC. Very likely. I'm given that mandate, my lord. Okay. My lord, yes. I am directed to enclose herewith a copy of the Government of India Personal and Training, Ministry of Personal, Public Grievances and Pension regarding the guidelines laid by the Honorable Supreme Court in their judgment, criminal appeal number so in the matter of Central Bureau of Investigation versus Ashok Kumar Agarwal, and the Honorable Supreme Court at para 7 of the judgment has observed there is an obligation on the sanctioning authority to discharge his duty to give or withhold sanction only after full knowledge of the material facts, and grant sanction is not a mere formality. Therefore, the provisions in regard to sanction must be observed with complete strictness, keeping in mind public interest and protection available to the accused against whom the sanction is sought. Sanction lifts the bar for prosecution. Therefore, it is not an acrimonious exercise, but a solemn and sacrosanct act which affords protection to the government servant against frivolous prosecution. Further, it's a weapon to discourage vexatious prosecution and is a safeguard for the innocent, though not a shield for the guilty. In paragraph 8 of the judgment, complete strictness by the competent authority, very important, competent authority, while considering the grant of sanction, extracts in paragraph 7 and 8 of the judgments. Sanction is a condition precedent for initiation of a prosecution of a public servant.
As the provisions of 19 of the BC Act, no court shall take cognizance of an offence punished on 7, 10, 11, 13, and 15 alleged to have been committed by a public servant, except with the previous sanction of the competent authority. Similar provisions appear in 197 of the CRPC involving IPC. No court shall take cognizance of this offence except with the previous sanction of the competent authority against the public servant accused of any offence alleged to have been committed by him while acting or purporting to act in discharge of official duty. The authority competent to remove the public servant. Very important manner. So my appointing authority is the removing authority, that person has to give the sanction letter. That's the law. Yes. And here, I'll go to the facts later. And if the authority competent to active sanction for prosecution. It has been made clear in the judgment of the Hon'Ble Apex Court, discussed in paragraph 1, that the object of sanction is to ensure discouragement of fraudulent, doubtful, frivolous, and impolitic prosecution against public servant to protect him from unnecessary and uncalled harassment involved in prosecution. It is a safeguard for innocent public servants, not a shield for the corrupt. Hence, while considering proposals of the vigilance, CBI, crime branch seeking sanction of the court, yes, on receipt of the separately proceed. Yes. These sanction may be helped with the investigator officer in the case. Sanctioning authorities and querying with the relevant material, yes, may include the FIR, the report of investigation of the SP, either of the statements from draft charge and other relevant material, if any, to make complete conscious scrutiny of the whole procedure, apply its independent mind, satisfy himself that there will be prima facie case against the accused, and accordingly decide to give or decline sanction against the government servant, public servant. Copy of the relevant material produced by the sanctioning authority may be retained in file for future reference for production in court. One can even ask for that. Yes. That the sanction authority should review the sanctioning authority had been aware of the facts and circumstances of case, perused and scrutinized the relevant material, and applied the independent mind in arriving in the conclusion that there is a prima facie case against the accused, and the public servant may be prosecuted for the offence committed by him in any other offences punishable in law. The time limit, very important matter. The time limit is prescribed by the Supreme Court, considering that the investigating authority 3 months, generally speaking. However, in cases involving substantial point of law, the sanction authority may take another month if it considered expedient to consult the law department or the advocate general. And seeking their views in the whole exercise was completed with the time period. The above guidelines may be meticulously followed. But let me kindly see the date of the sanction, madam. First. This is 3 for it's always 4 months. 4 months when after it came, and 6 months from the date of when the first FIR was first, my lord, he wrote to the it's part of the record. I'll show that, my lord. He wrote that it is 5% of the annual income, so we should ask for a quietus in the matter. We shouldn't ask for prosecution. No material after that, my lord. 7 months later, they filed they asked for sanction. And that material was not produced with the sanctioning authority. That particular matter. Which, my lord, is the law that one that tilts in favor of the accused must be produced. Yes. That is the test. Yes. And therefore, I'm saying, my lord, and that is very much available in the case diary. Yes. So how is it that they will not produce it, my lord? My lord can call for the lower court record, it will come with the lower court record, my lord. Next date, my lord, the call for it today, it will come. The registrar general can get it in 1 day, my lord. So not a big issue. You can get it. Mr. Das, do you just ask whether you have a case diary with you? Must be. You can't find the case diary in one diary. You must be having. It is a matter of 2006. Just ask me. I will ask. Otherwise, I'll pass an order. It relates to something. That's what proceeding is paid in this case.
Proceeding is
No. It was even,
I understand.
this was the by the special.
We cannot for the entire
Case diary. Yes. It is a case, one can always
case diary and
Manner Sambalpur Vigilance case number so and so. Initially, the matter was placed before the Learned Special Judge Vigilance Sambalpur. Thereafter, as this applicant was holding high public office, as per the Orissa Special Courts Act Section 5, a notification was made by the government to be tried under the Orissa Special Courts Act. Hence, this matter has been tried by the Learned Special Court. I lost the entire record. So, Sambalpur, whether all the cities are available with the Sambalpur Special Judge Court or Special Judge Special Court, I will not take, I will actually come down fast. Because initially, charge sheet was filed before the Learned Special Judge Special Court, Sambalpur.
when can you confirm? I'll pass the order accordingly.
I will ask both Sambalpur ST and Kathak ST to
Tell me apart the order. I hold it and pass the order. What day after? Friday you tell me in the morning. So that I'll give appropriate direction to the court concerned. Which court concerned court you just tell me.
So, on Saturday, so working day, election may fix to 5th October. I will probably confirm where the CDs are available.
Yes. Because those guys are available in excellent sort of material. Whether it was placed before the sanctioning authority.
Exactly, my lord.
That's the only thing he is arguing. And let us go with the root of unnecessary writing.
May I reply to
not to piecemeal.
only one sentence?
Yes.
You will also may kind of have a glance to section 1988. Section 19B. In the case of a person who is employed in connection with the affairs of the state and is not removable from his office save by or with the sanction of the state government of that government. Number one, state government of that government. Number two, 19(2). Wherefore, any reason whatsoever, any doubt arises as to whether the previous sanction was required under subsection 1 should be given by the central government or the state government. Or any other authority. Such sanctions have been given by that government or authority which would have been competent to remove the public servant from his office at the time when the offense was alleged to have been
competency. But he is saying
state government is the competent authority.
He is saying something else. Why don't you appreciate that? He says that the materials were not placed before the competent authority at all. At the time of
evidence is there. State government is the authority.
Again,
authority is a state government.
Authority may be, but whether these materials which form part of the what you call the investigation was everything was placed before me.
Specific evidence of people.
He only says that it was placed before me.
That's me and routed through him. Different higher authority.
But I know that
last week was.
But he says that the case diary which contains
government is not the appointing authority. State government is the appointing authority.
I understood. You have asked
submission.
I understood.
So further submission is I have already perused the general progress section every state government. 15 is what the appointing essentially authority has signed. What's the actually? That all the materials are provided for me, including a case diaries, etc.
If that case diary was placed, and whatever he says that in the case diary that was there, whether it was overlooked or it was taken into consideration, that is a matter of.
His evidence is clear, my lord. Your lordship, he only satisfied on the.
I am satisfied. I am completely satisfied.
Whether at this appeal stage when there is no question put to the IO, a single question regarding illegality,
that also you pointed out,
or incompetency of this nation,
Can it be raised for the?
It can be raised to Supreme Court also. That's the law.
Notwithstanding.
You have not, you say that they have not confronted with the.
Regarding illegality or incompetency of the sanctioner.
One of them argues better than
It was and it was proved sanctioning authority by standing in the box. As he didn't put a question in the cross-examination that you were not the competent authority to accord sanction. You were not, no document were placed before you were going through the same and sanctioning the accord. As a single question, being put in 1903, this provision which I referred to in the previous occasion, that no sanction or no final sentence or order special shall be revoked or altered by a court in appeal. Your lordship is hearing this appeal.
Yes.
Where is the question regarding illegality or authenticity or competency of according sanction? When the person signing the sanction order has been examined at cross-examined at length, thereafter the IO has also been examined. Why this question has been answered? How this new point will be raised in the appeal when the law provides?
No, it's not a new point, but he is arguing that the that part of the
law says so. 1903. Your lordship may kindly have a glance to 1903. Section 1903.
Yes.
And also on this score, I have given 4 citations of the previous occasion, my lord.
Yes.
Your lordship may kindly have a glance to those decisions.
Yes.
Categorically, I have cited the decision of 1972 criminal which your lordship will refer regarding this competence of this who is government and which state government on the previous occasion. So, glance to the last decision.
Come to the evidence of PW 15.
Yes.
Evidence then.
Yes. Volume 2.
Volume
2. Next. 225.
225. Okay. Yes.
Will I read your lordship please?
Yes.
225.
Yes.
On 5/4/2011.
Yes.
On 5/4/2011, I was working as officer on special duty in GA department. Prior to this date, the vigilance sought for sanction of prosecution against Sibo Sankar Mishra, DSP Homeguard Sambalpur, on the allegation of possession of disproportionate assets by him during the check period from 1/1/95 to 12/1/2006. The proposal was processed in GA department. And I held pre-sanction discussion with the IO Sri SK for the DSP Vigilance, DW17. Who appeared before me along with the documents in response to the notice issued against him. On perusal of the relevant documents produced and after discussion with him, I was satisfied that there was a prima facie case against the suspected officer, and after due application of mine, I prepared detailed note and submitted the file along with the relevant materials to the Honorable Chief Minister through the Deputy Secretary and Chief Secretary. The Honorable Chief Minister approved the sanction of prosecution, and thereafter I signed the sanction order on behalf of the government.
Yes.
The same sanction order is marked as Exhibit 22, in which Exhibit 22 is my signature. The same sanction order was communicated to GA Vigilance Department by letter number 7188, dated 6/4/2011, under the signature of J.N. Sarangi, the then Under Secretary, GA Department. The same authority letter is marked Exhibit 23, in which Exhibit 23 by 1 is the signature of Sri Sarangi, with which I am appointed. Cross-examination by 3. I do not remember the date on which the pre-sanction discussion was. During the pre-sanction discussion with the IO, with Perry, the meeting declaration report, details of personal notes and PCA report, balance, CA, purchase of paper, statement of suspected officer, witnesses, etc. The consider maybe the pre-sanction discussion. In this case, I have three sets of discussion with the sanctioning authority and additional secretary to department that later shall be going and also during discussion on renewal applications shown to the sanctioning authority. Additional secretary and the concerned department yes, on 692, 16 I got it in front of the board. This one I just want to take yes. And you tell me where that and what it is. I don't know where the signal produce before this actually and then I just want to see. I think this is long and problem. The union will all this. That 115 and 2008. Investigation report that time it was only 5.27 income. That's the and on 6/2009 it is now up to 38.7. So what are the medical maintenance that was buckets. Investigation is whether the time when you want to change my technical all the details and I can have and see the play before the century of the peak. It only say that from the river play. This part of the that it was only 5.47. It's very 15 and project. How is
Draw a proceeding and I'll continue. So I don't want to draw a proceeding. Let it go on. It may extend beyond 8 weeks also.
Limited to mention whenever.
Yes. Yes. Thank you.